I am also going live to our Facebook page right now.
Okay. All right. Thank you, sir. Good morning, colleagues, and welcome to our professional fees webinar. Welcome to this awesome Friday. I see the numbers are rising. We're at about 506 participants, which is totally fantastic. Thank you so much. Today we are holding our webinar from Durban, but I really welcome you all and thank you for taking your time to participate with us, to help decide the matters of the profession, and at the same time in guiding SACAP and SACAP's stakeholders in making informed decisions that are affecting all practitioners. I'd like you to please help me to welcome the members that are serving this committee that convene on a regular basis in order to help make important decisions that are affecting the profession. Today, I will start first with, we have the registrar, Advocate Dr. Fuduli, and then we have our council member, Mr. Simi Puritan, and we have the stakeholder manager of SACAP, Mr. Ntokozo Masango, and we also have our good president, Mr. Charles Nduku, who's going to be joining us a bit in a second, just to welcome everybody. And we also have another practitioner, Ms. Helene Grimsel. And I introduce myself as the chairperson of this committee. My name is Lithabisa Shongwe, and I'm also a practitioner, and I participate quite vigorously in this committee. We also have our secretariat, Ms. Mamuketi. I wish I could be able to go through all the names of the participants to individually welcome you, but that's about 560. But I note you and I see you and I welcome you. So thank you. Our first speaker of the day, Ms. Mamo, as president, as we're waiting president to jump in, who is going to be the first speaker? Ms. Mamo?
Yes, Chair.
Yes. In accordance to our agenda, while we await the president, who will be the first speaker?
Tabi, it's Advocate Fuduli is the first speaker.
Yes, no, that's fantastic. Okay, well, Retodo, can you kindly share your words and please take this platform and welcome our people. Thank you, Dad.
Right. Thank you very much, Vice President, and let me welcome all the participants, registered professionals, candidates, and other stakeholders who may be with us. I think today is a very important day because the issue of fees is always a big issue in the profession. And we've noted that many professionals use various methods to determine fees. And SACAP thought that perhaps it is best to have a discussion around the fees. And I'm sure professionals can learn 1, 2, or 3 things about the best way to do things. This may not be the best thing, or the best way to do things, but I think we will learn 1 or 2 things just to make sure that we're all aligned. So my presentation today it focuses on the issue of written agreements. You'll appreciate that the framework of fee guidelines talks to the issue of a written agreement. The code of conduct of SACAP also talked to the importance of a written agreement. I know that many professionals from time to time, they prefer quick verbal agreements and they start working. But we know that there are many risks involved when you take that approach. So we want to suggest a better approach today to safeguard the interest of your business and to safeguard your interest as a professional. So I will speak to 6 things, the contents. I'll introduce the subject matter and speak to the issue of the intent and purpose of a written agreement. Why is it important to have a written agreement? And also we'll look at the responsibilities and the scope of work. And all these things must be clearly outlined in a written agreement so that when disputes arise, things are in black and white in the paper. And then also, perhaps we'll also touch on the issue of enforceability and legal protection. You know, the benefits of having a written agreement will be articulated on that point. And also, I think what is important to talk about is the payment terms. And often professionals, and we see this from the complaints that we receive from time to time, often professionals can work from stage 1 until 4.1. You find that they've only issued 1 invoice. And at that time, the drawings have been approved. And sometimes you find that the client does not honor the payment, you know, that they've agreed upon. And you find that you're in a limbo. So that's what I will focus on. So the first thing is that generally, you know, a verbal agreement, a written agreement are all legal and are enforceable. So you can have a verbal agreement, you can have a written agreement in common law, but the code of conduct that binds all professionals requires that there must be a written agreement. The framework guideline professional fees also requires that there must be a formal written agreement. So you know, it may be tempting, you know, to enter into a verbal agreement, or maybe just have a 1-page written agreement, you know. But the problem will start when things change or when disputes arise, and that's when you find that you may be exposed as a professional because there's nothing written down. Because once it becomes your weight against your client's weight, then you may have challenges. And that's why it's important that each and every key aspects must be put down in writing. It is more safer to do it that way than to rely on a professional. And it also it minimizes the risk of disputes. I mean, when things are in black and white. So what is the purpose of the intent and purpose of a written agreement? You know, as I said, you know, handshake, verbal agreements work fine, but of course, things do change. Conditions do change. You know, clients do change when things are going tough on their side, or maybe they've got financial constraints and they start to frustrate you as a professional. But you will be exposed if you have nothing written down. So for that purpose, for that reason, written agreements will definitely protect your interests because they serve as evidence of the things that agreed, that you and your client agreed upon when you decided to work together. So you know, what must be taken home here is that it's all easy to say that verbal agreement is easy. We have agreed, I trust the client, it's very easy. But you must know that as a project progresses, you may have difficulties in terms of recouping your fees. You may find that you're giving so much time, you're giving so much hours, but you're not getting anything in return. And your practice suffers simply because you have not put everything down in writing. So it's important that you provide more certainty and have an agreement in writing. You know, it does not matter how big is the job or how small is the job. Get to the habit of making sure that there is an agreement with all the terms stipulated in the Rule 4.1 of the Code of Conduct, as well as the framework of fee guidelines, you know, because it also details what must be in your written agreement, the framework. So I think it's important that we understand the intent and purpose of written agreement. It is there to serve you, in fact, than anything. Don't be misguided, you know, by clients who want you to commence with work and they're not prepared to sign anything. Once a client does not want to sign anything, then you must know that you are going to have problems in the future. We move to the next point, which is the responsibilities. So once you are appointed as a professional, there are responsibilities and obligations arising from that contract. And as well, there are responsibilities and obligations for the client arising from that contract. And Rule 4.1 does detail what are the responsibilities of a professional. If you look at the framework fee guidelines as well, it will set out all those stages and what should happen in all those stages. You know, so here it's important to understand that a written agreement, it must spell out the responsibility of each party in detail. These are what you call express terms that are required by the code of conduct and the framework. But you must know that in any contract that you enter into as a professional, there are implied terms. And implied terms means that these terms may not be expressed in the agreement, but they're implied. For example, as a professional, you have an obligation to exercise reasonable professional skill, care, and diligence in the performance of your obligations. These may not be written in black and white paper, but those are inferred, those are implied. That's what's expected from you. So I think it's important that we make sure that before you agree to do anything, the agreement must be in writing. It must set out what are the services that the clients want from you, what are your responsibilities as a professional, what are your client's responsibilities. You must agree on the fees. And how are you calculating those fees? There's different methods you can calculate your fees. The guidelines, they do guide us as well. If there's a budget applicable for that particular project, it must also be stipulated. And also, how are you going to resolve disputes in case there are disputes? The issue of termination, the issue of peer insurance, all those things are quite critical, and they must be written down in a contract. So, but also what we want to add here is that a written agreement must also spell out the parties, you professional and the service provider. You as a service provider, as well as the client. If the client represents a company, the details of the company must be there. If it's a client acting in his or her own capacity, the details must be there. In case of dispute, you need to be able to contact the person and be able to resolve those disputes. In terms of, you must also have issues of performance. If you have your own obligations as a professional in a contract, and you must perform according to the contract. And if you don't perform according to the contract, what are the remedies available to your client to be able to enforce specific performance? You as a professional, you also expect the client to perform in terms of the contract. So the client must make sure that he or she performs. And most importantly, the client must be able to honor the payment invoices. That is very critical for you to run a successful business. Invoices must be honored, there must be cash flow in the business so that we are able to continue to serve our clients. The duration of agreement is quite important. The timelines, very, very important. We know that there are things that are beyond you as a professional, particularly when you have submitted an application to a local authority. But there are some things that are within your control in terms of your timelines, particularly in the early stage of the project. So there must be clear timelines, and it must be clear to you and the client what are things that are within your control that you can make sure that are fulfilled within the specific timelines, and what are things that are beyond your control. Your client must know those things from the onset. And in the event that things happen, you need to be able to be upfront with your client that in the event that unlikely things occur, the client must also be able to understand that if these things happen, things may be delayed and you may not be able to get your things in the time agreed upon. Also, the issue of variations. I mean, we've seen in most of the complaints that comes through that the allegations that professionals are changing, the scope of work, the services, and so forth without approval. So your contract must spell out, how variations should be handled. It's very, very important that your client signs off any variation. If you are instructed to vary what was agreed upon or add anything, make sure that you get a signature of your client, so that if there are disputes, to say that I did not approve this, then you are able to show in black and white that indeed the client would have approved this. The issue of copyrights, intellectual property, we know that our position has always been clear that the copyright when coming to any design reside with the client. But sometimes clients don't understand that. So this must also be in writing. It must be expressed in your contract. What is the position? And also you find that the issue of double drawings, clients always, will be writing to SACAP saying that this professional is refusing to give me these drawings because we want to make changes. It must be clear in the contract whether your client is entitled to that or not entitled to that. So all those things must be put in writing so that you don't have problems should dispute arise or things change as the project progresses. The next thing that we must understand is the issue of what is outlined in the guideline professional fees, because there's a lot of information that we may miss there. It's a long document. That guideline is quite a long document, but if you take your time and read it, you'll see that there's so much value that you can get from it. I mean, it also speaks to the Code of Conduct 4.1, Rule 4.1. It agrees that it must be clear. Agreed service must be spelled out. What is the authority of the professional? What is it that you can do, what you cannot do? The ownership of intellectual property or copyrights must be spelled out. The payment of invoices, interest on overdue invoices, the termination agreement, all these things must be spelled out so that you don't find yourself in a position where you're spending so much time and but there's no income, which correlates to the hours that you are spending. So it's very, very important that those things are in agreement. Also, in the fee guideline, you'll note that there's this point that if a client terminates an agreement, the fees for all work performed are payable immediately. That is what the guidelines provide. And over and above that, there's an additional 20% for the remaining fee that would have been payable had the project not been terminated. These terms must also be expressed in your agreement with your client so that your client knows upfront that they are not going to wake up in the morning and simply terminate a contract without the consequences and having to pay for that conduct. So these things need to be in your contract so that you are protected, because practices, I'm sure they plan ahead. So if you are going to be disrupted when you have already planned, you have let go of other projects that you could have taken, and then this happens, you are running at a loss. So that's why it's important to make sure that your client is fully aware the consequence of terminating a contract, particularly if there are flimsy reasons why that has been done. And then the issue of legal protection. I want to emphasize that while verbal agreements, are legally binding, they are very difficult and very complex to enforce when disputes arise, particularly because it's your word against the word of the client. Now, it's very, very difficult to enforce that. Verbal agreements have no records of objective specific details and terms, and it becomes an issue when there are disputes. So we want to discourage professionals from entering into verbal agreement. Even if it's a family friend or it's a friend, this is a business and it must be treated as such. An agreement must be signed. If you go to the SACAP website, there's pro forma, not invoices, there's pro forma agreements that are there. There's template agreements, either for a larger project or for a small project. I think SIAT as well have a template agreement. SIA has for many years have a template agreement called a client architect agreement. So we do have, these documents there. We just need to take them and use them fully for our benefits. So a clear and concise written agreement with all the relevant terms, it's important to protect your business. You know, particularly when there are disputes or your client does not want to perform in terms of the agreement, or they simply abruptly cancel the contract. You know, there must be consequences for that, so that your business does not suffer. Yeah, I mean, a written agreement also serves as evidence about the responsibilities of each party. You know, should disagreements, you know, arise, and it will help, you know, in dispute resolutions, because you can simply refer to what was agreed upon between yourself and the client. So for all intents and purposes, you know, it is a best practice for any architectural practice to have a written agreement with all the important terms that I've highlighted. And those terms, you will find them in the code of conduct. You will also find them in the framework, in the guideline professional fees framework. They are all there. All you have to do is to incorporate them. Or you take the template agreement that is there, you simply add what you need to add from that. In that way, you are able to protect yourself. You know, an agreement then serves as a legal protection to you in case there are disputes, you know, and the client will want to take advantage of you as a professional. The next point that is very, very important is the issue of payment terms. You know, we often get complaints from professionals that, you know, they've not been paid, perhaps, let's say, from stage 2 until the approval of drawings. At that time now, the drawings have been approved, there are disputes. The client decides to fire you as a professional and bring on another professional to carry on with the work. So now you are at a loss. You have not been paid fully for the work that you have already given to the client to commence construction. So it's important that you adhere to the basic terms of payment. You know, cash flow is a lifeblood of any practice, particularly the small and medium practices. You need to make sure that the payment timelines are in writing and they are adhered to. If they're not adhered to, your contract will give you a procedure to follow in case the client does not follow. So what we're saying here is that the payment terms are important for every project, regardless how small it is. So you must have clear payment terms, you know, and payment schedules on a written agreement. You must know from the onset by when payments should be made. In that way, you remain protected. If you look at the table in the fee guideline, it does guide, you know, in terms of from what stage what should have been paid. If you look at the table, you know, in the framework of fee guidelines, stage 1, you know, 2% of your fees should have been paid. So you must have issued an invoice for that. Stage 2, 15% of the fee should have been paid by stage 2. Stage 3, 20% must be paid. If you go to stage 4.1, 10% must be paid. So by the time the drawings are approved, 47% of your invoice of the work must have already been paid. So what is left now is about 53%, which now takes you to the next stage of you know, documentation and all that. So we need to make sure that we align our payment terms with the framework of fee guidelines. In that way, we know that we are protected. Now, late payment then becomes a breach of a written agreement. You would have stipulated your payment terms and at what stage they must be paid. And if there's no compliance by the client, then it becomes a breach of the contract. And when there's a breach and there's late payment, there's applicable interest for every month or part thereof that must be enforced. So I think it's important that we take note of this and make sure that we put this in our contracts, and then we can easily enforce. You know, in the event of breach of payment terms, the RP must issue a letter of demand, for example, directing to the client that they must comply with the payment terms within a specific timeline. That is very, 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 very critical. So it's important that we make sure that we enforce that and make sure that there is compliance. Now, I know that sometimes it's very difficult to enforce a lien because the drawings would have been already given to the client on site, and they will be used by that particular time. That's why it's important that you exercise your lien during the stage 1 until 4.1. If a client does not meet payment terms during those stages, at least you can still exercise your lien. You can simply withhold your drawings until all payments are done. It means that the project can't go ahead. Client must only receive the drawings, approved drawings, once all payments have been made in accordance with the stage that I've outlined earlier on. Because at least the lien will entitle you to withhold the plans pending the payment of outstanding fees. You see? So you can see from stage 1 to 4.1, you know, by that time, you should have been paid at least 47% of the fees. And if there's no compliance, then at least you can be able to terminate and claim damages, you know, for non-performance. So that is that in terms of what we wanted to present today. So what we want to emphasize in conclusion is that, you know, a written agreement is very, very important. And we must make sure that we enforce it and make sure that it's complied with. And let me also emphasize that SAIA, SACAP, and SIAD have written agreements, all of them, that can be used by you as a professional. You simply have to hit a template, simply take it and then tailor make it for yourself, use it for your business. And then also, you know, take written agreement as a risk management tool for your business. You know, in case there are dispute, then it begins to manage the risk that you may face, you know, between yourself and the client. So, Chair, I think in a nutshell, that's what you know we are presenting today, just to caution professionals and guide them in terms of written agreements and the importance thereof. Thank you very much, Chair.
Thank you, Advocate Dodo. Thank you for those words. I know there must be questions that are starting to come up, which is fantastic. You will get a chance to place your questions forward. I know that I already have two that are written. But however, I would like to just take this moment to welcome and allow our President, Mr. Charles Nduku, to be able to share his words. He's the chairperson of our council, the South African Council of the Architectural Profession. He is also a passionate member of the Professional Fees Committee. He is also a practitioner and has been practicing for a while. So he comes with great knowledge as well as experience as well. And he also has a guiding personality. And he's not an absolute ruler. So it's a pleasure to welcome him, my colleague. These are your people. Thank you.
Thank you very much to everyone. Let me apologize. I struggled to log in. Just could not allow me. So finally, I'm happy to be here. And this is a very good topic to discuss because it is at the center of our survival as professionals. And I think we need to treat it with an absolute sincerity and also the agency it deserves, because we need to really find ways to actually value our costs. And the current methodologies that we have now are being challenged by authorities, by client bodies, and we need to really look at new methodologies that we need to sort of investigate and research and then discuss and come to common understanding. With those words, thank you very much. I will allow you to take over. Thank you.
Okay. No, welcome, Prez. There was a bit of a sound issue there with you, but thank you for welcoming everybody and thanks for checking in. Colleagues, it's a Q&A session after what Advocate Dodo spoke about. Can you kindly come through and place your questions?
Yeah, thank you, Chair. I will
Yes.
start with Ricardo.
Fantastic, thank you. Welcome, Ricardo, go ahead, please. This is your platform.
He disappears. I'm going to Monica now.
Okay, Monica. Monica. Okay, I think while we are waiting on Monica, I have a question here which I also asked the registrar yesterday. Okay, and it's about the lien. So I've written here, I said, can you stop construction without incurring any penalties upon yourself as a practitioner should the client not have paid you all of the expected fees by the end of stage 4.2? Retoto, can you kindly answer us?
Well, I think it's important that the client does not get the drawings before all payment is made until stage 4.1.
Yeah.
Because once the client has drawings, either it be PDF and they are with the contractor, it's going to be very difficult to exercise a lien because you're no longer in control of those drawings. So it's best that you stick to that payment schedule, and the percentage thereof until stage 4.1. Because from 4.2 upwards, then remember now you're already dealing with the issue of the contractor, you are preparing for the site and all that. It's no longer about the drawing. The drawings must have been approved at that stage. So it will be difficult to exercise the lien, the VP.
Yeah, no, I like that. And as you heard earlier, the advocate said you should try to build it within, we should try to build it within our contracts that the client is not entitled to receiving PDFs or DWGs right up until the end of stage 4.2. Sometimes I know that can be a bit difficult when clients start wishing that you could send files, but if you can be able to see them in person in order to present these drawings, that will be even better, because then it'll be stipulated in your contract and then, you can withhold them until they have actually paid everything by the end of stage 4.2. Any colleagues that wish to ask questions? Mr. Munetsi? Okay, I see nobody is speaking. So I will read the questions here that maybe the advocate can answer.
Yeah, I've got Brian right now. Brian, you can go ahead.
Okay.
Brian Rob.
Yes,
Okay,
thank you.
Yes, Brian, thanks.
How are you, man? Sorry, this is just slightly on a different tack, but it's all revolves around fees. I've been at the game for a long time, and I think as most professionals, especially as oldies, in the old days, the fee structure was something that was almost enforced by SACAP, and one wasn't, you weren't basically allowed to negotiate and reduce your fee. Whereas today, I think with all us professionals, it's like a free for all out there. And in some way, I wish there was a way that we could bring that back to a point where we all more or less stuck to regulated fees as such, because that's what often happens. You end, like you say, protecting your cash flow, having written agreements. But at the end of the day, clients these days are very quick to barter and say, oh, well, I've got Joe Soap who will do it for 10,000, and then you say, oh, well, and so it's this the whole professionalism, as for me, has gone out the window in terms of what is due to you as a professional, the amount of work you put in. the fee structure is basically become a bit of a joke. That's just my comment. Thank you.
Okay. Brian, that's a very good question that you have asked. I think firstly, I will tell you yes, it is unfortunate how business has been dealt lately, but unfortunately we can't go back to where you are saying there was a time that the fees were rigid, because Competitions Commission was at SACAP's neck and they were saying that we are colluding when we're trying to fix the fees. So the way that SACAP reviews, the way that we view the fees currently is that they are a guide. And as much as possible that we try to use them as a guide, try to go as close as we can to that. But you'll see as the day unravels, and I know you're going to stick around, and I'm hoping you'll stick around. You know, we have some practitioners that have been at this for a while. And I can see that Simi has his hand up, and he's also a member of this committee. So he's going to be able to answer you quite nicely there. Simi, please go right ahead.
Well, I was going to say that I think Brian and the people who agree with him, I'm going to deal with some of those issues around the guideline fee and methods, ways of calculating fees. And I think the discussion around that is better after my short presentation. I think I'll put forward a clear view on fees, which should spark some debate.
Thank you very much.
Okay, thank you, Brian.
Can I come in there?
Next, it will be David. David, you can go ahead.
Hi there, can you hear me?
Live and clear.
Yes, loud and clear, David.
Yeah, so I just have a question for the advocate. So one of the challenges that you find is every once in a while, even with the best agreement, you end up in a situation where you would want to get yourself out of the predicament you're in, okay? And potentially you have a client and you and them are not necessarily getting on. So in that situation, you technically can resign from your contract. But my question is, in that event, what would you do with SACAP to ensure that you don't get a complaint against you later?
Okay. Let me come in the chair.
Go for it.
Yes, I think if there are disputes and the RP is not getting along with the client, I think it's best to terminate, exercise that option which is there in the contract, and terminate the agreement. When you terminate an agreement because you're not getting along with your client, that cannot amount to improper conduct. You are simply being fair to the client to say that because of these disputes, I'm not able to offer you the best service that is expected from me as a professional. Because remember, I spoke about implied terms. That as a professional, it is implied that you are going to offer, you are going to do your best, offer your services with due diligence and care. And if there are disputes, you're not able to meet those implied terms, I think it's best that you resign, terminate, and the client must pay for all the work that you have done. And then from there, you go your separate ways. That would be my advice, Chair. Thank you. Okay,
and in that sense, would it be wise to refer that to SACAP, or is that not necessary?
Well, it's not necessary. If it comes to our desk, we'll be able to handle it, to indicate that, the reason why there's a provision in the written agreement for termination is precisely for these kind of situations, that anyone between the parties can terminate. But we need to make sure that you are paid for all the services that you have rendered, and then from there can go a separate way. So you don't have to do that, but if it comes to our desk, we'll be able to assess it and be able to guide the client properly.
Thank you, Advocate.
Thank you. The next speaker is Monica. Are you ready?
Colleagues, Advocate Toto, just before, are you talking, is Monica the next person with a question?
Yeah, I've got Monica and Ramali. Yeah.
Okay. All right.
Two.
Go on, Monica.
Okay, Monica is not responding. The next one I'll open is Ramalia. Can you go? Okay, Monica, go ahead.
Monica Chibuda, let's have your words.
Sorry?
Yes, you can
All
ask
right.
your question.
Ask your question, Monica.
Yes, you can go ahead.
Okay, no, it's fine. The next one, it's Ramalia. Please go ahead.
Yeah, I think you was talking about Ramlal, Ray Ramlal.
Oh
Is that
yes,
right?
sorry for pronunciation. Can you go
No
ahead?
problem, no problem. We're in a democratic country, so you're entitled to your clarity of how you pronounce. Welcome, no problem.
Hello, Ray. Welcome. Thanks.
Morning. I think from my side, as FACE, we want to firstly thank President Charles Nduku and Advocate Dr. Fululi for piloting the profession to a wonderful level as it stands right now. And today we have a wonderful discussion regarding fees. Just one question I have with regards to fee payment as presented by Charles Nduku, where he mentioned that from 0.1 to 4.1, all payments by client, should be made. However, we all professionals are having a serious problem because currently the administrative action by the local authorities all over the country in South Africa are issuing approved plans directly to clients without our authority. How do we overcome this situation? Because whilst a contract talks about, part payments at various levels, before even we receive the plans, the clients have the plan in their hands, and then there's a dispute with regards to outstanding fees. I think that's a very, very important point, is what is SACAP going to do in order to inform the local authorities that the applicants of a particular application for plan consideration is the author of the plan and not the client. How would SACAP help us in this regard? Thank you.
Colleagues, is there anybody that wishes to express a solution? It can be any of the participants. Perhaps in their experience, they've been able to find a solution. Attendees. Okay, we have a person, a gentleman here. Okay, is there anybody that wishes to answer for our colleague there?
So can you briefly recap the question?
Yes, Mr. Ramlal was saying that also Vera Platt is also asking in the same way that you would have the plans submitted to the council or to the municipality, and you find that the client already has a copy of these drawings and you hadn't yet concluded on your payment. Mr. Ramlal, did I ask your question correctly? Did I?
Yes, you are on track, but
yes.
What the local authorities are implementing now is on the application form, it is a request that you provide them with the client's email as part of the administrative on the application forms. Now, what that causes is when the clerks on the other side who are not understanding their duties and they're not well informed as what they should be doing in order for a better development, and what's happening is they just adding all the emails, and be that as it may, if I've got 50% of my fee outstanding and the client's got it, he's gone overseas, you would not catch him. That's the problem.
Yeah. Yes, Dr. That's a very, very strong question. It even leads to as much as what Ray is saying is where you are now going to be finding that commentary that's meant to be going through to the professional to fix their work is also going to be going through to the client. And then the client is not understanding the order of things, that comments are things that happen and that you're going to need to get time to be able to do this. So, so yes, please help us there with this.
Well, I think perhaps from our side, the SACAP, what we should do, we should be able to communicate with the local authority that when a professional is involved in the submission of the drawings, all correspondence should be directed to the professional, because there may be outstanding fees.
You see,
and they may find themselves handing over a product that has not been paid for fully by the client. And in that way, it compromises the professional. So these are messages that I think we must convey to the local authority, say that please be very careful here, because we are dealing with complicated matters. And clients can be, once they've got the drawings and they've been approved, they can be very difficult when you have to collect your fees for that product that they have. And they can easily discard you and go seek the service of another professional who will be happily, to take over the work and carry on. And that's why in the code of conduct, we've made it clear that if a professional is brought in a project where there are already drawings, that professional has a professional obligation to actually engage the client who worked on those drawings to understand whether he's been paid for the work, because that work cannot be used if payment is not.
Sorry, so you mean the professional, sorry, not the client.
Yeah, so if the client brings in a new professional and discard the previous professional who designed the project, in the code of conduct requires that the new professional to communicate with the professional who originally prepared those designs to find out whether the fellow professional has been paid in full before he can be able to take over. It's an obligation that we all have to protect each other, because clients, can exploit professionals if we are not careful. And if professionals don't work together to protect themselves against these scrupulous clients.
Yeah.
So Chair, we will communicate with the local authorities. I've taken note of this, and then we will engage them, because we do have MOUs with the eThekwini, for example, where Comrade Ramlal is, City of Johannesburg, City of Tshwane. So we will communicate.
Yes.
Chair.
Another colleague here made a comment in the chat saying that in Cape Town, with City of Cape Town, it's extremely hard to be bypassed as a professional because of the power of attorney and the fact that they really respect that power of attorney. They take it very seriously. Okay, do we have one last question before we move on to the next speaker?
Please, can I come in one more time?
Okay, Mr. Ramlal.
Thank you very much. Thank you. I think also we're talking about a good contract and a well-exercised duty by professionals. I think on one of the platforms we did talk about what would actually help professionals through the guidance of SACAP for a shorter contract, a smaller contract. I'd like somebody to just advise us if anything is still on the process of that, because that would actually help. If you're basically just doing an enclosure of a window or a door, smaller projects rather under probably 500,000 or something, Thank you.
Yes. SACAP has, they have the extended client architect agreement or architect professionals client agreement, and then they have one that is for the smaller projects. And so the other one is maybe something like 7 or 8 pages, and then this one is something like about 3 or 4. Am I correct, Advocate?
Yes, there's a simpler version for small projects that has been approved by the investigating committee. It's on our website. I think everybody can download it and use it as they deem appropriate.
Okay, and then Advocate, I have a question, because I have a mother that once told the church that I'm going to design her church for free. Now, when it comes to pro bono work, Are we still expected to sign contracts with the client? And maybe at the bottom you say 0.00 fees. That way, then at least the terms are in there.
Yes, I think it's best, to use a written contract, because it becomes your road plan, it becomes your action plan, because
Okay.
you know what you must do.
Okay.
And when it's verbal, you agree that you're going to do 1, 2, 3, 4, and once you've attained those, is there is in writing, it becomes easy.
Okay, that's fine. I think if we can have I'm taking one last question because I see now the different hands that I had hoped to be up. Yes,
it's
sir.
It's only one, Peter. Then we'll take the rest on the next round. It's only one. Peter, you can go ahead.
Okay, Peter.
So one of the solutions that we've often thought about in this problem with planning approval and fees not being paid is most builders have to do way leaves with building inspectors before any sort of construction can take place. Why are we not introducing this sort of way leaf system with building inspectors and with builders that are registered with the NHBRC, even that no building or construction can take place without the architect's approval? And in doing that, because what's happening is if a client's plan is approved and 2 years later through disputes, the architect is tired of running after these clients, they forget about it, but then they go get their plan and they eventually start building maybe 2-3 years time. So I think it should be a ruling that no building can take place unless the architect has given an approval with the building inspector to say, yes, you can go ahead. And we've been given the permission because ultimately we are responsible. So responsibility does not just stop when the plan has been approved.
May I come in there? I think it's an interesting point, but may I offer another suggestion, which is that remember that when you produce a building, when you do a design of the building, the copyright resides in you, and you are effectively giving the client a license to use those building plans for the purposes of building his building once off. What we probably should do, and I'll take this back to Saya as well, is to explicitly state in the contract that this explicitly state that it is a license to use the design for and the plans for once-off building, and that license can be revoked in the event that fees are not paid. And that would be a reasonable way. So, for example, if there are approved plans, but the client hasn't paid, then the license to use the plans are revoked.
Yeah. No, I like that. I think that's a first step at assisting the problem. Okay, I think we can now move on to our next speaker, and it will be yourself, Simi. Simi.
Yes.
Yeah, Simi Puritan. He's a practitioner practicing from Cape Town. He's also a constant and consistent member of a South African Institute of Architects as well, and he's also serving on this committee in SACAP as an advisor, as all the other colleagues, and his vast experience in practice also allows him to bring across interesting findings and some solutions, and also some questions that are leading us to think differently about the future. Thank you, Simi. And he's going to be talking about understanding the different types of fees.
Good morning, everybody. I hope you can all hear me, and I'm going to see if I can share am I sharing the screen? Can you see the first slide?
Yes, you can see it.
Right. So yes, I'm talking about the ways of calculating fees, which shouldn't be strange to everybody. Clearly, the ways of calculating fees, you all know about the percentage based on construction value. That is essentially the guideline fees. There's obviously the time-based fees, and by that I mean you simply agree a rate per hour and an open-ended rate per hour. for very small amounts of work, and that's a time-based fee. Then obviously there's the square meter rate, which is not commonly used. Certainly it's not commonly used on the bigger projects, but some people have advocated its use, and I would like to hear comment on the success of using a square meter rate as a basis. And then finally, the task and deliverables based. Deliverables meaning drawings and schedules. So you don't call them just drawings; they're also schedules. And my own view is that given our dialogue with the Competitions Commission, I believe that the guideline fees at some point will probably be abandoned, and people should prepare themselves for a fee based on the actual work, an estimate of the actual work to be done. I'll talk about why that is a preferable way of doing things, but I'd love to hear your comments. On the percentage based fee, the base data upon which the guideline fees are based, the base data has only recently been assembled after many years of using, if you like, outdated data. Recently, the SACAP Fees Committee a few years ago engaged with an actuary who now serves on the Fees Committee, and we have been using the base data from the SIRE and the SACAP fee surveys. So here's a plug for all of you to please take the fee survey seriously. It is used as a foundation for understanding the guideline fees and for advocating for guideline fees. And by the way, the fees survey was a reason that the Competitions Commission accepted the guideline fees as a basis. And we can talk about that later. I'll explain why if someone wants to know. The base data has only recently been assembled. But the problem is working practices have fundamentally changed over the last few decades. By that I mean the increasing use of 3D software and the increasing cost of 3D software. We've also, and this is a point, I saw some questions from the previous speaker, one size does not fit all. In the guideline fees, the fees committee is at pains to state that the guideline fee is an average. It's an average fee. There is no one project that fits that fee. It's not as if you're offering a discount on a guideline if you offer less fee or if you offer more. The point about a guideline fee is exactly that. It is some form of average. Every practitioner and every practice needs to judge its own practice and its own costs and its own location to decide on what the fee should be. And that's a critical point, and I'd like to come back to that. You cannot, the fact that one doesn't achieve a guideline fee is neither here nor there. In fact, it would be strange if many people achieved the guideline fee, because that would mean that their project fits perfectly into that average and that middle ground, which is unlikely. There'll be very few projects, and in fact, if you look at the fee guideline, the fee surveys, one of the charts that convinced the Competitions Commission that in fact the guideline fees was not resulting in any collusion was because when you look at all the individual projects, the fees for all the individual projects, you find that they are spread across a wide range. Anyway, the last point here is that the legislative environment is much more onerous now. As you know, we've got land use, which takes longer. We've got building regulations, which is ever tighter, and you've got environmental legislation and so on. So all of these contribute to workloads that are either more or less depending on where you are. And of course, a percentage-based fee weirdly stays the same whether the service changes or not. And that is something that means that the percentage-based fee blindly applied is really a bad fit for defining an architectural service. So the basis of a task and deliverables based fee, what is the basis of it? And here's where all of the practitioners have to do some work. The first issue is obviously costs. You have to understand your costs, and the costs are essentially broken down into salaries and overheads. And of the overheads, they're broken down into expenses, admin staff, the cost of admin staff if you have them, the non-productive time, the time, for example, from a single practitioner who spends part of the time attending webinars and marketing their services, going to meetings, that's non-productive time. And of course, risk work. Risk work is an overhead. If you don't get paid for it, it has to be recovered somewhere. So those are some of the key factors of an overhead. Then you need the hourly rates. How you calculate hourly rates is a critical function as well. And what one must understand is how many hours in a year one is productive. And here you see the fundamental calculation. If there are 254 weekdays in a year, you have 9 public holidays, you have an average of 5-6 days a year, and therefore you're left with 240 productive days. With those 1,800 hours, you have the following. When I talked about non-productive time, you might have staff time not related to projects where they're doing other things other than literally working on a project to advance the project, maybe about 10 to 15% of their time. So you'd have to put that as an overhead or reduce their productive time from 1,800 hours a year to 15% less than that. The associates that one might have in an office, they might have to devote more time to office management issues. Their time might be, their non-productive time might be as much as 25%, and partner time, not related to projects, related to getting work and other activities, might be as high as 40%. And what that means is that when you try to calculate average hourly rates, you finally arrive at a figure, something like these figures. If you look at the SACAP and the SIA fee surveys, you'll see the average hourly rates, which if you do your own calculations, you should be able to benchmark your hourly rates against the average hourly rates in the surveys. But then what is quite illuminating is this slide where one sees that if one, for example, this is a very simple example, if one had a team consisting of a partner, an associate, an architect, and a technologist at full time throughout their time on a project, the average cost would be 712 Rand if you use these rates. It's just an example. What happens if the associate and the partner, so the average cost per hour is 700 Rand per hour, and you can multiply that by 1,000 hours, whatever it is, to over the life of a project. But if the project only has half partner time and half associate time across the life of the project, the average cost goes down to 537 Rand an hour. Now that difference shows you how critical it is that the actual staff and the cost of the various staff members on a project, if you're going to use hourly rates, is critical. You can't just use an average hourly rate unless you know more or less the makeup of the team. So this was just a slide that I thought you'd enjoy. The percentage of the work inspired by Corbusier, and obviously the percent of my clients who know who Alva Aalto and Le Corbusier are clearly the red bits in the circle. Now, what is a task and output or task and deliverables based fee? Well, you have to define the tasks, and the tasks are design time and admin time and model building time, and then there are specific tasks per work stage. And in fact, SIA, until recently, for a long time, Fresh Projects offered a free fee calculator which included the specific tasks per work stage. It is no longer on the Fresh Projects task fee calculator, but it should be made available again as a list of tasks for SACAP registered professionals, and I recently found out that it wasn't any longer available on the Fresh Projects fee calculator, but I'm happy to try and make the task schedule available, kindly developed by Andrew Cunningham of the South African Institute of Architects. So yeah, it would be, if you can see, the amount of time to design and the amount of time for door schedules is probably a bit exaggerated in the slide. But what a task an output-based fee, what the schedules look like, and I'm giving you just a few examples. This, if you can see this is the tasks related to concept design, concept design and viability stage 2. This particular version is related to shopping centers because it has a section around tenants and leases. But of course the principle applies. The principle that I'm trying to describe applies whether it's a shopping center or not. This is an example of the design development task schedule, and it looks onerous to start, but once one understands and gets into the way, this methodology of calculating fees, it becomes clear that this is probably the way forward, as it is currently in the UK and in other parts of Europe. And this, if you can see it, is an example. This is an example from our office. Of course, I've changed the costs. If only staff hourly rates were £10 an hour, just added this. But this is, for example, how simple it can get. Here we have just simple drawings, drawing numbers, titles, an estimate of the hours associated with each drawing, the fees per hour, and a total fee. And this is the bottom of the schedule, and you see at the bottom in red a number of tasks, allowance for hours for meetings and design iterations and so on. The 25 hours at a higher cost would be for example, for a partner or an associate. And one builds up a fee, you see a contingency there as well. One builds up a fee by understanding the work that is required to be done. So what is the advantages of a task and deliverables or output-based fee? Well, it forces one to examine the process. It means that you really look closely at what you have to do. It's helpful in explaining the process to clients because, again, when a client says they want a discount, you offer them a fee and they want a discount. To not have what is very easy to use when you do a tasks and deliverable schedule and associate fees with it is you say, if you want a discount, Mr. Client, here's the tasks and deliverables that I'm intending to produce. Tell me what you'd like me to omit from the schedule. And I will omit them and the fee will be less. So it is very helpful in explaining the process to clients. It's useful, as I've just explained, to negotiate fees. And in time, the more you use it and the more you use timesheets, it will build into a database of costs, and you'll understand the relationship between your costs and the fees that you need to charge to make a viable business. The disadvantages is this is where most practitioners are quite fearful. The lack of initial data, the lack of where to start with this is daunting, and one should seek help from mentors to help you get into the process of analyzing the tasks and deliverables needed. The lack of detailed data until you build up a database of some sort, and that applies most specifically to the time needed to build the various models if you use BIM, if you use Revit or ArchiCAD or other 3D packages, because it's what you saw on the schedule previously is a series of outputs. In other words, whether it be a plan, a section, an elevation, those are 2D outputs. But what isn't factored in there, because as it happens in that case, the model was already built, what isn't factored in there is the task to actually build the model in order to allow yourself to extract the output, the 2D output that's necessary. So there are some challenges to starting to do to base fees on tasks and deliverables, but they can be overcome by willing mentors to help you do this. The way forward, as I see it, is well, we need a supplement to the client architect agreement. There are some key elements, because a task and deliverables based fee is based on exactly that, your estimate of the work needed. And in order to do that, you need to sign off each stage of work so that abortive work, you don't carry forward changes which are absorbed into the fee because you didn't get the proper sign off per stage. With that comes what should be a mandatory change control procedure. In other words, you should explain to your client what he is agreeing to at a sign-off, and then what would constitute a change which would attract additional fees going forward from that sign-off. And I think, of course, a detailed schedule of tasks, deliverables, and responsibilities would tie all of this together. Originally some time ago I talked about fees and costs at a previous webinar of sorts, not SACAP, but at the time the serious research on fees and costs hadn't been done. But I'm really pleased to say that SAI and SACAP have, over the past number of years, done the research necessary to give a firm basis for the guideline fees at this stage. As far as changing the percentage fee allocated to stages, SACAP fees committee in, I think, 2 guideline fee iterations ago did change the front end loading of the initial stages to a certain extent. Whether SACAP fees committee went far enough, that is up for debate, and you should have been aware of the fact that those more fees, a higher percentage of the fees were allocated to the latter stages, because all of us should know that the percentage of fee allocated to the construction stage probably doesn't even cover our costs. But part of this also should be an awareness of what the consultant scope of work is, defining that more precisely, and defining what you intend to do in relation to the 3D modeling, or BIM, is also added complexity to the fee issue. There other considerations really are, again, a voluntary charter of excellence where higher standards would be expected of practitioners who wish to subscribe to, as I said, higher standards. The registrars already, it is mandatory to sign fee agreements, even for pro bono work, because even work done for free comes with responsibilities and liabilities. There is no, you can't discharge that if you're offering a professional service. Whether in the long run, either by SACAP or by the Competitions Commission, a mandatory description of tasks and deliverables is going to be imposed, that's a debate that I think will be had over the next few years. I've already mentioned mandatory sign-off and change control, and of course, one thing that is not yet fully adopted in South Africa is a common BIM standard. I know the BIM Institute and the CSIR are busy with a BIM protocol, probably adopting the European standard. I think not probably. I think the CSIR has published a white paper where they recommend adopting the European standard. Yeah, that's an overview of the fees. Questions?
Colleagues, please go right ahead and let's ask questions and let's get talking. Anybody wishing to say or ask anything?
Yes, Chair, I've got four hands here. I'll start with Councillor Mohamedin.
Okay, go ahead, Councillor Mohammed. My fellow council member at SACAP.
No, it's a past question. I think it's with Mr. Ramlal, where the fees, like Mr. Ramlal complete the work with a client at stage 4.1. So we should make sure that he do get his, the agreed fee before. He should put in his contract before 4.1 that he do see that he get all his, the fee that was agreed upon. That is all. Thank you. Thank you, Chair.
Okay, next question or comment?
The next person, it's Abi.
Yes. How are you, ma'am? Yes.
How are you, Remoloi?
I'm okay, Mel Tabiso. Good morning, all. Good morning, all participants.
Yes.
My question, I typed the question from the earlier speaker, from Advocate Fiduli. My question was, we are servicing mostly villages and townships where the issue of the percentage-based fees becomes a problem. We normally use the square meterage fee form, which is not regulated by SACAP, and mostly I'm from an organization called it's a voluntary association which will be registered soon, I think, with SACAP. Mostly our members are from these areas, and it's a problem starting with how do we charge our clients. That's why we use the square meterage fee system. Now, I would like to know if SACAP is intending to regulate the square meterage system, because some of our members, especially those who are new in the industry, they end up charging next to nothing. And we believe it's killing the industry. Yeah. It's an exercise that we as an organization are trying to resolve, but we believe with the engagement of SACAP, this might be, there might be a solution for that. That was my first input. The second input is that with the issue of percentage-based fees, which predominantly you need to have either the budget from the client, or you might need to calculate yourself, calculate and create some kind of construction cost of that building. The part that you create in the construction cost of that building, because some client doesn't give you the budget. They just say, well, we need this. And you need to go and create the construction cost of the building so that you can get the percentage-based fee of that project. The part where you create a construction cost, do we have to be paid for that? Because sometimes we need to include the quantity surveyor to do that for us. Those are the two questions which I wanted to raise, Mamshong. Thank you.
Thank you, Babamloi. I like that you came through and put your hand up, because you are exactly one of the people that we want to be hearing from. You know, we try to communicate this out to other RPs that SACAP wants to hear from all participants in this profession, especially when it comes to the square meter rate. Yes, I've heard about it. I know some colleagues are using it, but I don't have the experience to be able to fully comment on it. And one of the things we were talking about yesterday with the registrar is to vigorously try to get some of your colleagues and yourselves in and to participate with SACAP. But I think maybe the president can be able to, would you like to comment on the square meter rate situation, Perez?
Yes, yes, Chair. Thank you, sorry.
Thanks, President. Okay.
Yeah, I think the square meter rate, I've seen it, the American Institute of Architects, you know, is actually putting that out as one of the methodologies for calculation. And if I hear the question properly, it says how do SACAP regulate that? In other words, maybe come up with rates that are reasonable. If I understand the maybe that's what he wants to find out. That what are reasonable rates for that? Because if I understand him quite correctly, the rate varies from maybe a professional to a professional. Yeah, I think it is something that really one needs to understand when you embark on that methodology, because it is key, it is critical that you understand your service. You understand the value of your service, the cost of your service. I mean, Simi has always mentioned this, and this is actually the problem as a profession we are having, where we are begging to actually pin down our cost in terms of the details, rather than using methodologies that are based on square meter or based on construction value. And then, you know, we should be in a position to actually drill down to details of how much does it cost you as a professional to dish out that service to your client. And I think it goes back to the question of throwing down the list of overheads, what you need to actually be able to have in place to service that client. I think it differs from an individual or a practice to a practice, because other practices are small. And I think this methodology is usually used by the is used for small projects, very small projects. And I think it is it's very difficult for me to give out an outright answer to say this is the rate that you should be using. But you know, there are guidance that you probably can look at in terms of the hourly rate. You can bring that in and see how, and you compare.
I don't think, can you walk home to Tabani? I can't leave here.
Sorry. Okay.
Very
Yeah.
impressive.
Yes. So it's a difficult one, as I'm saying. I think it depends on an individual's costs, you know, that he has to work out, you know, because you have to factor in the disbursements, the overheads, and everything. The software, you know, if you are you have an employee, you know, how much that, you know, do you bring in that employee cost, which is like the telephone and overheads. It's a very difficult one to actually pin down, to say, use this rate. But I think what is important is that's why I'm saying, whatever you do, check it against the time, the rates that we have on a time-based fee. If how are you doing? Are you not wasting your time? Are you not running at a loss? Are you and each and every individual works out his or her profit. You know, for me to profit in what I'm doing, this is how much I need to charge. you. So it's a very difficult question to say, use this figure.
I think, can I come in there? I think that the issue around square meter rate, the problem is there's no research on it. At least with the percentage fee, there's been a history of many years of the use of that as a benchmark. There's a very limited pool around the square meter rate. It has the same deficiencies as the percentage. In other words, you know, whether it's all relative to the work that one has to do. If a job has a land use application to go through as well as building plans, that's one type. That needs to be added to the fee. If a job needs an environmental impact process, that adds time. If the kind of procurement is different, that adds time. If you don't have to do every single, if it's not a full scope of work, then it's different. How do you apply square meter rates to all of this? So really, whatever the methodology would have to be tested, and that's quite a difficult and costly exercise, because of course you can gather information about square meter rates that are being used, but you don't know whether they're being used with a successful outcome, because as the person said, some people are charging ridiculously low square meter rates. The only way to verify any of this information is to sit down with on Excel spreadsheet or the open office spreadsheet, and to work out the tasks that you have to do, the outputs, the deliverables that you have to deliver at each stage, and what that costs you. And maybe we need a seminar, a webinar just on that, with working examples to teach people how to do this. Because even if you use a percentage-based fee or a square meter rate-based fee, you should check it against your estimate of what you have to do and how long it will take you to do that. One thing I can say, and I think it's an important little caveat that you should add to the fee, and for example, to a percentage-based fee, certainly. When I certainly check the percentage-based fee against the, if you like, the estimate of hours, I always put.
Sorry, Mr. Putin.
Yes.
Sorry, Mr. Putin. You know, I'm just concerned. From your side, it seems as if you're just chatting away what other people are using at the moment, and those professionals might have been using this system for a long time, to a certain extent that they can come up with some kind of a system that can work through SACAP. Why I'm saying this, Mr. Puritin, is that we've got our members who've been using this, and they seem comfortable with it. And we normally do workshops with the fee issues, especially relating to SACAP percentage-based fees in the rural areas and the townships. Now, my concern is that we tend to differ in the types of the fee part, whereby one would say, I'm charging 50 rand per square meter. The other one will come and charge 200 rand per square meter. I would like that to see if it's a proposal that can that portion be regulated by SACAP. That's my concern.
Yeah,
that's my concern.
Thanks, Babamloy. What I hear you, and I think what my colleague Simi was saying is exactly to help you to answer that question, because the reason why some of your colleagues are charging the very different square meter rates is that no one actually really knows what is the cost of doing work. And the way Simi is explaining it is what we've been debating lately, is to come to a point where we start building up an itemized spreadsheet, to work it backwards, you know, we build it up. I have to do a ceiling plan. I got to do this and I must put plumbing. Okay, the client doesn't want plumbing. We put it in. And then we check. And then you check, how long does it take? How long does it take? How long does it take? And what are the hours? And what do those hours mean to you financially? Whether it's 300, 400, or 1,000. And then you come to that total and then you divide it backwards in order to start coming up with the rate. Now, your problem, I get it. It's because there's colleagues that are charging 11 rands per square meter. And there's another guy who's charging 50 rands a square meter. And then there's another one charging 75. And you want to know, but then what is it, you know? Because you can't go and compete with a guy who's charging 7 rands per square meter. So now what I'm glad that you said is that you are now formalizing a VA. And as soon as you can come and get it registered with SACAP, all the better, because we want to hear what you have to say, because it informs, we are all in the interest of a viable profession. So get that VA registered and then with SACAP so that you are able to participate with SACAP in a better way. And also maybe with the next coming council, if you could be able, the next coming council committee selection, you could be able to put your hand up and say, look, I'd like to help SACAP and maybe in the professional fees committee. It'll be fantastic because those different ways of calculating and the different ways of doing business is what's going to help to inform the committee. And in the committee, we sit there with calculators and we sit there with an actuarial scientist, you know, he's a big numbers guy. And he helps us to actually see what should be plus minus a viable, sustainable square meter rate that also will yield you profit. And at the same time, something that SACAP can be able to possibly gazette, because we know that the winds of the future are changing. We are aware of what's happening in different continents, and we are also being told by CBE and those other places and those other councils that we need to start finding other ways, but they have to be tested ways. They need to be tested. I'd like the president to step in to be able to answer you there, Babamloi. Okay, yes. Prez is going to say something. Yes, Prez.
Thank you very much. I just want to just piggyback on what Sino was saying, that, you know, I think SACAP is in the process of research, you know, to work out the actual costs for all types of, you know, fee calculation methodologies. I mean, this one of the rate per square meter is also, you know, in that survey, if you can also put in your information there as to how you calculate your fees, so that and make the suggestion wherever you can. I mean, to feel free to talk to SACAP about that. But all I know is the American Institute of Architects, you know, around this topic, they mentioned a percentage per square meter of between $1 US to $5 US. Like you translate that to rands, is between 15 rand to 77 rand per square meter, and then in between, you know, between 15 to 77, you don't know where you fall. And what informs that? You know, what informs that is exactly what Sin is saying, that is based on the task that you will be performing there. You know that this, for me to do this task, it will cost me so much time. It will take me so much time, and therefore I should attach this cost to it. So you need to find a way to come down to the rate that is relevant for you to charge, and then and it's not going to be, it's going to be very difficult to actually say or regulate and say you should be charging 5 rand per square meter or 10 rand per square meter. That's what SACAP is. If you're expecting SACAP to say that, it's going to be very difficult. Competition Commission and it's gonna be good. Whatever we do, whatever we say, it must be based on scientific evidence, data that you can assist us, Mr. Morod, to actually put forward as evidence of it costs you so much to actually do a bathroom extension because you feel there's an argument. Basically, that's what it is. It's difficult to give you an outright answer, but you will need to research on this. Thank you.
Yeah. Thanks.
No, thanks, Brother Charles. Thanks very much.
Yeah.
Thanks for that. Yes.
Yes. No, thanks, Babam Loy. So go and register that VA.
No, it's already registered. Don't worry, ma'am. It's already registered.
Lovely.
Yeah, it's registered in 2019. We just doing the SACAP processes.
Okay.
Can somebody answer my second question now?
Your second question was in being able to figure out the cost of construction and whether you should be charging for quantity surveying services. I think maybe another colleague can answer that.
Well, the short answer, if it's just in the initial estimate, is probably not. Certainly, if you're going to be asked to do work for a client, one should have a broad idea of the costs, because generally speaking, you've done something similar. So the budget is just that, a target budget upon which to base fees. Certainly, you can suggest a quantity surveyor is asked that question, but again, it's when you first go into a fee negotiation, really it's a question of you defining how you see the work, which in this case would, for example, be it's a building of 100 square meters, in the past it's cost 5,000, 10,000, 15,000 rand a square meter, and therefore that's the budget, depending on, and you must put all the caveats that you need to and the qualifications, for example, depending on the level of finish and depending on the complexity of the structure and depending on the condition of the ground. So this is really just a guideline first attempt at a budget estimate. We've had this debate internally with the advocate because in the code of conduct, the question of what issues you have to cover in your fee agreement, one of them is budget. And of course, if you haven't had experience with that building type in a similar condition, then you probably should seek advice outside, and that professional may very well want to charge for that advice. But generally speaking, if for example, if I've done a house in wherever, similar house or similar size house, I would apply a square meter rate based on the last project that I worked on that was similar. I hope that gives you some answer.
Yeah. No,
Yes, Simi, no, I get you, Simi. Now, it seems as if the square meter rate issue comes in on that, so that you can be able to get your construction cost to create a budget. The square meter rate issue comes in.
It does.
Now,
in that sense, it comes in. That's the
yes.
relationship between the percentage-based fees and the square meter rate. We can convert percentage-based fees, construction cost-based fees into square meter rate by simply dividing the whatever percentage you come up with by the square meters. But I think the issue is this: it also comes down to the scope of work. In the rural areas, I don't know whether a full and given the size of the project, I don't know whether a full service is being offered. Maybe you're just doing building plans, and maybe it's a very, very basic set of drawings. Which, as long as you explain that to the client and you believe, or it's common practice in wherever you're practicing, then that's the scope of work that you and what you're going to give the client. That's different. different if the guy, you know, whether another person will offer a full scope of work and someone else offers just building plans, building, you know, the plans that would be submitted to council, whether it's hand drawn and whether it's done by computer, because then the costs are different for those two practices. So there's so many variables. That's why certainly I strongly advocate to get a grip on your costs, where your costs came from. That was what I was trying to emphasize in my presentation. Get a grip on your costs and translate those costs into a fee, and then work the fee backwards towards a square meter rate or a construction percentage based rate. And by the way, the point I wanted to make before I think you stepped in with a question is this. I often these days write in the words whichever is higher next to the fee. So for example, even if it's a square meter rate, you say the fee is 50 Rand a square meter, whatever it is, times the square meters, which is this, or the final square meters that are actually built, whichever is higher. Not so. In other words, if they decide to build a smaller, your fee doesn't go down. That's a problem in the industry generally, where it could be that the tender price comes back lower, or the client decides to make a smaller house. Doesn't mean you're doing less work, and that's the problem with these arbitrary or these guidelines, square meter rate, percentages. If a project is slightly cheaper or slightly more, doesn't mean you're doing more or less work. Generally speaking, the common complaint that clients make is, why if I want gold taps, why am I paying a fee because I want gold taps instead of chrome taps? You know, and that's not even. And of course, we at SACAP get the question often that we find even in public works. They say, oh, they're going to omit the cost of the air conditioning from the architect's fee calculation. And we keep saying it doesn't matter what you omit or don't omit. Ultimately, the fee is a guideline. If you omit the cost of air conditioning, and that brings down the overall cost, and therefore the fee is less, but the architect needs more money because the fee costs for him costs more, then he must just get a higher percentage. So in a sense, it's a guideline. It's simply to provide a basis to start understanding your fee, whether it's square meter rate or its percentage rate. Ultimately, you have to understand what it costs you to deliver the service.
Okay, no, thanks, Simi.
Yeah.
Oh, that's great. Thanks, Mr. Moloi. Thank you for the question. I saw a lady here. We haven't yet had any commentary from a lady, and this lady has a hand up. I think I saw her name, Morongwe. I hope I pronounced it right.
Yes, you have. You can call me Ntabise.
Tabi, go ahead.
Thank you. I know we're talking about fees, but not everyone is a consultant. Some are actually employees. And I know that you cannot regulate or give a guideline on how much employees should be paid. But some issues, because you're not getting a fee, affect you as a professional. I'll give you an example. I'm a salaried employee. I work for a large organization, and the intellectual property belongs to the organization. And but when I have to submit under my own name with my own professional certificate. Now the issue there is we do not have indemnity insurance. So I just want to ask, can the organization SACAP form some sort of guideline or some sort of regulation on the inclusions that need to be made if you want to employ a professional on their full capacity, for things like indemnity, for things like intellectual property. I'm not sure how to phrase this, but I find it quite an issue that I'm not getting a full fee. I'm not performing I'm performing in my full capacity, but I'm not getting the whole professional, I don't know how to call it though, but the liability is thrown to me as an individual, even though the intellectual property and the credit for the work is not placed on, I don't carry it with. I'm not sure if I'm very clear on what I'm asking, but is there a way that SACAP can step in on the terms in which a professional can be employed if they're not going to be taking the responsibility as I don't know how to phrase that part, but yeah, I don't know if you understand.
Yeah, I think I kind of understand you, that you're saying one is an employee. When you go to the municipality to submit, you need to sign the plans with your professional registration. So it means like you're taking on responsibility, but you're not getting the reward of the intellectual property, as well as you know, the fees are not necessarily coming to you. Is that what you're kind of saying?
Yes, yes.
Okay,
So,
I think, yeah, I think, you know what, I think the registrar is the perfect person to help to respond to that. Retoto, can you talk about that? I think we were even talking about it yesterday or something.
Yeah, I think that's a difficult one because that's a space that SACAP has no authority to enter into. You know, I always say that we must always remember that SACAP is a statutory body, and all what we can do is clearly stipulated in the Act. And beyond that, will be acting unlawfully. You know, the reason why we're discussing guideline fees is because precisely Section 34 of the Act authorizes SACAP to publish guideline fees, and that's why we're discussing that, because we have authority. You know, as much as we can engage the principals and influence them and guide them, but ultimately we don't have authority. You know, we can be able to speak to volunteer associations to take up these matters, because the role of volunteer associations is precisely to discuss issues that impact on their members and see how they can guide each other to improve the system. So it's something that we can take it up with our VAs to consider and make sure that perhaps there are controls in place to protect individuals who are exposed in that kind of environment.
Yeah, my concern is that the organization I'm referring to is a large organization. How do you influence government? How do you influence municipality in such a thing? We don't have unions as professionals, and the Act, as you say, protects mainly the public, you know. So it's a very fuzzy area for us professionals.
I think with government, we should be able to directly engage with these departments. Because SACAP falls under the Department of Public Works and Infrastructure. And if you write to us and indicate, you know, which department in particular, we can be able to commence a dialogue with them and try to find a solution to these kind of problems.
That would be much appreciated.
That would be the best approach, I think, in my view.
Thank you. I'll give it an attempt. It would be appreciated.
Yes, please, just share your contacts, your email with us. And then the challenge, and then we'll take it up with the relevant department.
Yeah, okay. Thanks, Murongwa. You look also familiar. Were you from my school in the past? Okay, maybe not. Okay, there's another lady here that I'd like us to just give a chance to ask. Her name is Tracy Deeks. Sorry, colleagues, it seems like I'm not deliberately jumping mails or in order, but I think that we've had a couple of mail questions. So I can take liberty to jump and ask Tracy. Tracy, can you ask your question? Tracy Deeks. Tracy. Okay, Baba Mnetsi, perhaps you can, maybe then the next person on the list is, I see, is Ferdinand.
Yeah, yes, Ferdinand Olivier.
Yes, Ferdinand Olivier.
Yes, thank you very much for taking my questions. Listening to Simi there was very interesting, and I agree with his point about the signing off on the different stages of the project and the record of that. I think that would alleviate a lot of the issues. As I see it, our appointment happens in two stages. What we've mostly been talking about now after Simi's presentation here is the initial argument of how do we actually land or secure the project. I think one could say, and I don't want to string this thing out discussion out for too long, but one could just say that there is a sort of a honeymoon period there, and if somebody approaches you for a project, he already knows that you might surely has established that you, a person with all your practice, have the skills to actually perform the project or produce the project that he's wanting you to do. So the fee negotiation is very much already on a good foot, if you like. The negotiation as to what the actual fee might be, I can see there's a lot of questions there. And a long debate can still ensue around this. I want to move to the second part where you actually have now been appointed, and into the project you're starting to pick up the risks, and the risks are more evident towards the end of the project, where the fees have mostly been used now in your cash flow, and the project turns out not to be the one that you envisaged. And heaven forbid, you could never even have foreseen this if you had gone in on a price per square meter rate and so on. Because of various complications, the project has escalated or has projected a complication, or produced a complication along the road. We have a situation recently on the project which we signed up for, and has thus far extended to a 15 days working days extension, and 3 different contractors on same site without an overarching project manager to coordinate these things. How does one recover? You can't go back to the client. You can't say to the client, listen, I'm going to stop the project because it's become anything. It moved on from what we signed up for. Yeah, I think my question is, how does one deal with that scenario? And it's a difficult question, because how long is a piece of string, and there's 20 million different variations of what I'm trying to explain here. I think,
okay.
Yeah.
No, I hear you, Ferdinand, and maybe the registrar can talk to this, because I think it has a lot to do with the agreement. And you have every right to go back to the client, because now it means the picture of the project has changed from what it was initially. Reto, can you help answer this, please?
Yeah, I think I missed the gist of the question.
Okay. Yeah. Maybe okay. Let me ask Simi to perhaps to package it for us.
Well, I think the question is really, you have a fee and the project changes some way significantly, and how can you go back? Well, that absolutely does come back to the fee agreement, and how and it comes to how carefully you pay attention to describing what you believe is are the parameters of the project when you offer the fee, and that really is important. If you and of course you can't have every eventuality, but you need to make certain assumptions about the project, and you should state them in your fee letter, which is why, by the way, the tasks and deliverables schedule that would accompany the fee, not necessarily each task having time associated with it, but the overall schedule of tasks and deliverables would give you much greater definition of the project than any other way. But having said that, if you don't do that, even with square meter rates or whatever, try to think through the issues of the project and the parameters of the project in terms of duration, complexity, number of statutory submissions, all of the assumptions that you're making that let you arrive at the fee, rather than just writing, my fee is X, and that's the end of that. If you pay attention to the fee agreement, all the points that Advocate Faduli made, plus there it is in the code of conduct, which gives you a nice checklist of what you should put in the fee. Go further and put as many assumptions. If you feel there's risks, put those assumptions down if you can. So think about the project that you're going to embark on, and write it into the base fee agreement. That's the best protection that you've got, I think.
Yeah. I really like what you're just saying, Simi. Ferdinand, just to also so Retoto, what Ferdinand is saying is that he has this agreement, he embarks on this project with the client, And then far down the line, you know, the picture of the team also changes. Suddenly there's 3 contractors. There wasn't maybe a project manager at the very beginning. Suddenly he needs to maybe to over an extra manage on the project, or you know, there are all of these new complexities. On, I don't know whether it could be like a sudden huge rock underneath the building or you know, in the site. But then and then he says, yeah, but I can't go back to the client and tell him now this is 1, 2, 3, 1, 2, 3. But he absolutely can. And what Simi is saying is that build in those possible scenarios, like imagine whatever, and then you say in case this, in case that, in case that. So maybe you can speak about not shortening the agreement, but rather making it as exhaustive as possible.
Yeah.
Go on.
No, definitely. I think Simi is right. You know, it's important that in your written agreement, you've got a variation clause. If anything changes in the project, then you must sit down with your client and vary that contract.
Yeah. The variation I was talking about wasn't really related to design or anything like that, but more on the contractual side, where the actual duration and in the process of construction.
But for example, I mean, that just to
end, you know,
no, but that's the point. For example, you can state things like you're basing your fee on an expected duration of contract of 18 months or 15 months, and if it goes to 25 months, you've got an opening to negotiate. You can also say you can base your fee on the expectation of a standard JBCC contract, for example, and then if that changes, so what I'm saying is you can put down, and they don't have to be complex. You can put on some certain. Basically, if you've practiced for a while, you should probably know, you've built up a years of experience of where things can go wrong, what parameters of a project can change, and if you just very simply make those assumptions on your basic in the front of your fee agreement, it doesn't have to be massively long, but there are some key ones, and you'll get caught out from time to time, there's no doubt, but it'll cover the main ones. Duration is probably one of the biggest. Contractual complexity is another one. Statutory submissions is another one. Number of iterations of design that you're prepared to do before you charge extra is another one, so that you don't get clients that are going around and around in the design process. These are like four lines, four bullet points on a contract, for example, on a proposed fee agreement.
Yeah.
Thanks.
Okay. You got that. You got that, Ferdinand. You know, I was once told by an attorney when I started using contracts, and I was thinking, no, but it's too wordy. It's too wordy. And he says, you know, the more you put in there, the better it is, because it governs your relationship, and they also respect you, because it shows that you're also respecting yourself and your time by noting these things. Like Simi says, it can be simple, but best that it should be in there and exhaustive, and then you're covered.
Thank you.
Yeah, no, fantastic. I think then we can take one last question, and then I think we're going to need to move to a coffee break. Councillor Modine, I think I'm going to skip you because you've had your question. Sorry, my good colleague. Yes?
It will be Tumelo.
Okay, yes. Tumelo, yeah. No, go ahead, Tumelo, please. My Lula.
Hi, how are you doing?
Read me speak.
Yes, sorry. I just wanted to touch on the rate per square meter. That's when I raised my hand, but I think it's been overly exhausted now, so I put down my hand already.
Okay.
Yeah.
Okay, and then
it will be Engrobet Francisco. Engrobet.
Okay. Please go on and ask. M. Robert. Okay. All right, then Jonathan, and then Mr. Modine. Jonathan Stone.
Hello, can you hear me?
Yes.
Okay. I
Donald.
have, yes, that's fine. Anything you like, anything you like.
Okay.
Nominative determinism. Right. It occurs to me that we've been here now for over 2 hours, and somehow all this talk of fees, I'm very concerned that nowhere has the kind of real concept of our professional obligations, legal professional obligations in terms of the Architects Act come to the fore, because you know, primarily fees are one thing, but they are a reflection of that professional responsibility. And one of the most significant components of that professional responsibility is the professional insurance that one is obliged to carry. Now, how is it possible that anybody can offer a full professional service with all of the legal ramifications, and I've been in practice for over 35 years, that come to bear without carrying a significant professional indemnity? In fact, any of my bigger clients obviously demand it, but it doesn't matter how small a job is. If that house burns down because you're doing the smallest little garage alteration through some sort of consequence that you might have been responsible for, you are in for serious trouble. You know, the sort of minor rate per square meter calculation, the task, whatever that is sort of organized to sort of substantiate a fee, it doesn't seem to take into account any of those things. So would somebody care to talk to that, please?
Okay. No. Yeah, Jonathan, that is a very passionate point. In fact, I think the registrar did touch on something like that at the very beginning, where he always emphasizes that within the contract.
Well, I've been here since the very beginning, and I didn't hear any talk about that, I'm afraid.
Okay, I think it's because, firstly, maybe perhaps this committee is just zooming into the matters of fees. But
yes, fees must take everything into account. When you pay your gynecologist, you understand why it is so expensive, because of the extraordinary PI insurance that they carry, for example.
I can answer.
Go on.
Firstly, I think while it hasn't been explicitly stated, I think that firstly the comment around calculating your costs, your hourly rate costs, includes expenses, and expenses includes professional indemnity insurance or any other insurances that you carry. That's the first thing. The second thing is the guideline fees that have been published by SACAP are based on the last number, or not the last one. The last one, the one before that, was published on the basis of the SIRE fee survey at the time, with various adjustments that were made due to the various expenses that we believed were being if you like, underrepresented in the basket of calculations that make up the fee calculation. So in fact, professional indemnity insurance is part of the costs of running a practice and forms the basis of the underlying basis of the guideline fees that if you look back, I don't know if you're a SIRE member, but you should be able to get a copy.
Of course,
okay.
Of course I am.
Then have a look through the SIRE the surveys that are published, and I believe it was in the SACAP fee survey as well, the question of the breakdown of expenses across a practice, and on those expenses are obviously legal fees and professional indemnity insurance, which is a cost.
Okay, no. That's that point. I accept. I accept that. It doesn't explain how it is that one, at the sort of what would you call it, real throat-cutting fee end of our profession, sad as it is, that those are taken into account. So let's put that aside for a moment. But this task and output discussion that has been put on the table too, where it appears that it is sufficient to be able to, if one's client wishes to reduce his or her fee, then what you do is you start omitting certain tasks that, perhaps they don't need. Now, that's not that's not entirely straightforward, because, one can't avoid the professional responsibility associated with the entire thing. And it's very difficult to perhaps stand up and say and divorce yourself from the responsibility because you left this out or you left it out. As a professionally responsible person, you're obliged to point out a series of things, and you can't ignore or walk away from or negotiate your way out of taking professional responsibility for something. And I'm concerned that the sort of what would we call it, tailor-made service has a tendency to do that. Perhaps someone would talk to that.
Maybe let me come in, Chair. Just to correct Jonathan.
Go ahead,
He probably missed this slide. I made it clear in my presentation that a written agreement must have these terms, including PI insurance details.
But you can't exclude yourself from professional responsibility.
Just hold on, let me explain. So what we are saying here is that part of your responsibility as a professional is to have a written agreement with your client.
Yes.
And your written agreement must have the following things in them, including details of your insurance details.
Yes.
Quite important that that information has been explained. It's just that no one has dwelled into this issue and discussed it. But it is not correct that this issue has not been discussed today, because it is part of the fees. It is part of this discussion. It's just that we are the first one to raise this issue. And I think that's what the Vice President was trying to explain before you interrupted. I just wanted to clear that so that the VP can go on. Thank you.
But you've accepted the fact that people will have a verbal agreement.
No.
I know you're advising against it.
No, what I'm saying is that in South Africa, our law recognizes a verbal agreement, but our rules, the code of conduct and the fee guidelines require you as a professional to have a written agreement. So I was trying to give you a distinction between the law as it stands today and the regulations as promulgated by SACAP.
So then how, in terms of, say, our Architects Act, are a whole lot of building professionals operating at, putting themselves out to be professionally registered persons and in fact pretending to offer a professional service when they're not in fact doing that?
Well, it's something that we are working on. In fact, what we have done, we've brought in somebody with a policing and criminal law experience to focus on those cases. That person will commence his duties very soon. He comes with a wealth of policing experience. He's going to be dealing with matters that you see. People are opening websites where they claim to be providing, agricultural services. All those people, we are going to go after them one by one to protect the profession from these people. So it's something that we're working on. We will work closely with the police, because this person comes with a huge policing experience, with relationships with the policing, also with the prosecuting authority, because that's where we saw the gaps. What we're seeing is that when we report these cases with the police, they don't understand the statutory offenses that are created by our own legislation. And therefore, that's why we need somebody internally who has policing experience. We can equip this person to make this person understand these statutory offenses that are created by our legislation. And therefore, this person can go back to the detective and the prosecutor to be able to explain this offense. And then more people can now be prosecuted for posting these things on Facebook and other social media platforms, misleading the public. So it's something that we're working on.
No, that I accept, and I'm pleased to hear that that's taking place, and that's all very well. But what I believe is, in fact, incumbent on us as a profession is for us to look at ourselves and to ask ourselves whether there are really quite a significant number of our own membership who participate in the sort of real cut and throat business of offering extremely what they might consider to be competitive fees, which is in a very difficult market. But the only way that that is possible to do is if you can offer an inferior service.
Okay.
As simple as that.
I accept that. Yeah, yeah. I
And
hear you.
that is our fault.
Yeah.
Yeah.
No,
Okay.
no.
Yes. All right. I think colleagues, for now we can break for coffee. If we can make our coffee break about 15 minutes, those who take tea or however, and then let's kindly please come back at about 11:45, and then we're going to hear from Ms. Grimsel. Yes, and
Something that's 11:45 would mean it was 25-minute break. So maybe
yes,
it should be a
thank you.
10-minute break and 11:30 rather.
Yes. 10. Let's make it then 10 minutes. 11:30. Let's round it off. Yeah, and stretch our legs a bit. Thank you, and please do come back. Yes, and let's continue these lovely discussions that affect the pockets. Thank you. Okay, colleagues, I hope we're all back. The time is 11:30. Yeah, and I think I'd like us to carry on with our session today. Our next speaker is Ms. Helene Grimsel. She is a practitioner and she's been practicing for a long time. She's a director in a big firm, and she participates very passionately as well in the professional fees committee. I think one of the things that we also appreciate about her angle is that from her involvement in some of the past committees in the professional fees, she's able to assist us and remind us about history and what fees were back then. So she's a valuable member of this committee. Ms. Helene, I would like you to come in and take the floor and speak on your topic, that is understanding the fee adjustments and variations.
And thank you for the kind introduction, Madam Vice President. As Toby says, I'm discussing fee adjustments and variations. Yeah. I'm going to be stopping my video and start sharing my screen.
Thanks.
Can everybody see my screens clearly?
Yes, I can see them. So I think we can.
Good to go.
Go for it, Helene.
All right. Fees, adjustments, and variations, something that's very exciting for us in terms of what we will be discussing in this section. A short introduction, we'll be speaking about the work stages, a scope of service negotiations we'd like to introduce you to value add opportunities. We are also looking at the queries and clarification requests often received by SACAP in terms of this portion, and then we're moving on to a conclusion. Let me just try and introduction. So we work hard for our money. So why is it so hard for us to ask for our money? I'm just struggling with the slide. So it is very common for creatives like ourselves to determine our value. It is subjective if you are in a creative industry, and it is very hard to quantify and therefore ask for money. A lot of creators suffer from what could be called a seller's shame. We are ashamed to ask people for our money. A lot of people in our industry, no, actually all of us in our industry, we are incredibly passionate about what we do. And how do you put a price on that passion? We have to understand the value we generate for our clients, and that everything we do makes a difference in the world, in the built environment. The best way to combat this is to know what you are worth and then to earn it. But we do not know our own value, and our clients determine it for us. And I think you will all agree with me, 9 times out of 10, it is less than what we are worth. But the SACAP guideline professional fees do just that. It guides us to determine what is our value and what we are worth. So in my little quote box, I added an additional little caption. People will tell us we are less than what we are worth, but that will not be the SACAP fee guidelines. One of SACAP's mandates is the welfare of the profession and to determine our fee guidelines. We must learn to use these guidelines as a basis of a solid agreement with our clients in terms of what we will and what we will not provide. And as in the previous section, please always do this in writing. So we are now going to discuss how to use adjustments and variations to the standard fee to increase our value. The first item we will be looking at is work stages and partial services. We all know that it is divided into 6 general work stages, and I have used the colloquial name here for concept design sketch plans. Please note that in the 2021 fee, certain percentages has changed. You will see inception went down from 5% to 2%. You will see building plan submission has also gone down from 20% to 10%, but tender and construction drawings went from 10% to 20%, and construction drawings went from 27% to 30%. Now, if you are asking yourself, how was this determined by the fees committee? What we did is we asked some practicing architects. There are a large group of practicing architects serving on the fee committee to bring in existing projects where they are running timesheets. And we then evaluated those projects so that where we are spending time on the project, the percentage follows that time, and therefore the cash flow follows the amount of work you're doing in a certain time. I think everybody here will agree that at the moment, once we get, for example, get to the construction stage, we are tending to spend more time on site. Says something about the quality of contractors out there. With items like Revit and BIM, we're spending more time on tender and construction drawings, and that is why we have changed the percentages. SACAP also gives us the option to have a partial service, and there lies great power in a partial service. We often find that a client asks for a reduction in price. They use the words, "I don't have money for your fees," or "I can't afford your fees." Because we are so absolutely passionate about what we do, and by being personally invested, we've seen the site, we've built the image of what we want to do on the site in our head, we accept the reduced payment and we say we will offer a discount. But why don't we renegotiate the service we provide? So as an example, I want to share a spreadsheet with a group. I believe that the pen is mightier than the sword, as we always say, but nothing is as mighty as an Excel spreadsheet. This is an Excel spreadsheet that we've developed in the company. It is based on the Proxa services and deliverable annex. To create a spreadsheet like this in your own company, you will require a good record, mostly timesheets, to say to you which part of the services and deliverables take which portion of time in your specific practice. Or you will need a good gut feel. And of course, you can change it and adjust it over time. If in project 1 you felt it was slightly different, you change it for project 2 and 3. So by now we have got 3 columns: a service not provided, a service provided by the others, and a service provided by the architectural professional. As you can see, we've ascribed percentages to a certain stage. The fee in terms of the Proxa is 5% for a percentage, and we've divided it between 100%. Now we can very clearly, by attaching this to a fee proposal, tell the client, we are not going to advise you on the procurement policy. We are not going to advise you on other consultants and services. But you've said you are going to appoint somebody, for example, to do council submissions for you. We're also not providing that service to you. So of the 5%, we will only be doing the work of the 2.5%. So if we skip to work stage 2, you can see we've done exactly the same here. We're not going to agree a documentation program with somebody. For example, here, we're not going to discuss things with the local authorities because you've got a plan runner, and they will also be doing the submission of the site development plan. So, for example, of the 15%, we will do 10.5% of work. If we go to work stage 3, now this project is far-flung. He is appointing somebody locally to do a certain amount of work, this client of ours, that we are doing things, they're doing things, we are doing things as the service provider. And again, we are splitting fees and removing fees. So for the AP of the 20%, we are only doing the work of 14.5%. We skip to work stage 4. And all of these items you will find in your proxa. Like I said, we've ascribed the percentages in our practice, what it is, and now we divide it. And so we go through this. But by attaching this in terms of your, once you do your agreement to the client, there is nothing that has not, in a way, been discussed between you and the client of what service you are and are not providing. So if we get to work stage 5, we now have somebody locally on site that's reviewing the tests and the mock-ups. We're sharing perhaps the shop drawings with a local consultant. And so you go on and you play with your Excel spreadsheet as you go on. On closeout, we're saying we're not doing the payment valuations and the completion certificates. You might have somebody on site doing it. We're also not providing you with a maintenance manual or any guarantees or warranties, etc., etc. So at the end, you get to a certain sum. So now you see the AP did 53.86% of the work. The other person or persons or QS or whoever was appointed did an additional 41.24% of the work, and certain services was discussed with a client will not be provided. In this way, you can tailor-make your discount, so to speak, to the client who says, I don't have the money to pay for your service. You can tailor-make by reducing your service to the client, agree the reduced service, so that what he pays you better suit your pocket, but your input for that money has become far less than what it previously was under a full scope of service. So the power of the partial service in terms of negotiating fees, make sure it is in writing and save yourself the time, the effort, all these additional steps that you would have done by value of the contract. Save that time and save your client the money, but you don't have to devalue yourself. You don't have to devalue your service. And in that way, you do still get paid what you are worth. So our first instance, know your scope of service and know how to utilize it in your company to determine what you are doing exactly, and then when you are doing it. The next thing that we'd like to discuss with you is in the SACAP free agreement. There was a lot of time spent on additional value add opportunities. And with a value add opportunity, I mean that can add to the value of the fees you are asking the client. These are not part of the standard scope of services, which is included in our fee basket. But because we are so incredibly passionate about what we do, we tend to do a lot of these items for free. Again, when you agree with a client beforehand, agree what you will do for free or included in your service basket as a way of augmenting your facility, augmenting your service to them, but also know what is not in your standard service and have the discussion of what I will do for you in addition to my standard service and what my fee would be. In the guideline fees, there are certain of these items where no percentage or suggestion has been put forth by SACAP. They are items like special design services. For example, a big thing is marketing materials. That is not part of the standard scope of services. If your client wants specific marketing opportunities to market their townhouses, additional perspectives, rendered plans, boards with pieces of materials on it, that is an additional service. And by talking to your client regarding this additional service, you can ascribe a value to it, thereby growing your fees. The other thing is sectional titles. If they're planning on selling it on a sectional title basis, all the paperwork surrounding that, it is not part of your standard service. Make sure you know exactly in terms of what is your standard service and what are these additional value add opportunities. Take the shopping list to your client, discuss it with him, agree with him, and with that, you increase your worth to him because you're doing additional work for him, and thereby you are increasing your value in terms of the fees you can earn. Other special services will be special management services. For example, additional assistance with a budget, drawing up a cash flow. It's normally items that, for example, a quantity surveyor will be paid on a larger job. It is not part of the architect's general service. If you have to do that, have the discussion with your client in terms of what is the worth to him, therefore what is the value to him, therefore what is the fee you can charge for it. Special inspections is another thing. Going to site more often because of the contractor, you're assisting the contractor more than what has been agreed. Agree beforehand that my standard service includes me being on site so many times a week. If there are special inspections, I'm going to send this person or I'm going to go myself, and there will be an hourly fee. Have the discussions beforehand. The other one is special studies that we can look at. Everybody that does Green Star ratings, for example, they know the amount of additional work this takes. Why offer it to the client for free? If you didn't do it for free, your client would have gotten a Green Star rating specialist, and he would have very happily paid money to this Green Star consultant to do the Green Star rating. Ask if you are giving that service to them, there has to be an additional money coming into your little fee basket to do these things. Traffic studies, things like, sorry, that should read point cloud, my mistake. Surveys, drones, that is additional stuff. You would have gotten somebody to go and fly a drone. The fact that the architect has a drone, it doesn't mean it automatically has to be part of your basket of fees of everything we do because we're so passionate and we do it for free. Have this on hand. The other one is special submissions to the authorities, land use, environment, heritage. Doing a liquor license, there is an additional amount of work in everything of this. Make sure that you charge your value for these special submissions. All other services, like for example, your client gets involved on your site, there's litigation with a contractor, that is not part of the standard scope of services. You have to be able to go to your client saying, we are now going into a litigation program, you are suing your contractor because he was late for whatever reason, I need to be paid for my time. I need to have my value recognized for you because I am worthy of this. Then, there are certain SACAP instances where SACAP suggests what the increase in the standard fee percentage would be for an additional service. Make sure you have them at your fingertips. So if you, for example, there was another architectural professional appointed, the client wants to move over to a different type of service for whatever reason, there is an additional 25% there in the stage in which the service commences. So say it was in the working drawing stage, that 25% is so that you can go through the work, make sure what is there, do a bit of a recon. That has been ascribed or suggested by SACAP. If you have to deploy an employee onto a site for whatever reason, the site is far-flung, there's an additional 30% on top of the cost of the employment for that service. If your contract period is longer than initially seen, so the SACAP guideline fees discuss a 10% longer period, you are entitled to hourly rates. You priced when you did it that you will go out for 2 times a week for a period of 6 months. Those 6 months have now become 9 months. Those additional 2 site visits for the additional 3 months will have hourly fees as part of them. Have a discussion, ask the fees. Fast tracking, they want to very quickly get on site. The contractor is fast tracking. You need to appoint additional staff. The fee guidelines allow you the cost of your additional resources plus 30% for you to be enabled to service a fast tracking site. Traveling time, the fee agreement allows that part of your standard service is that as a round trip, an hour out to site, about 25 kilometers, that is part of your fees and it is encapsulated in the fee calculations that the fees committee do. Anything over and above that, your site is suddenly 4 hours away. A time charge starts applying to that. Make sure you agree this with a client beforehand. If your client asks you to, for example, pay another consultant as part of your scope, or they want a quote, for example, a model builder for you to obtain for the client. In the SACAP, especially under the disbursement portion, there's attendance of 10% that you can charge for doing the service. It takes you time. Your time is valuable. The other one is project-specific software subscriptions. The client or the developer uses a certain software sharing scheme that needs to be purchased. They are utilizing a certain software for the snagging of their things. You are entitled to recover that money. You don't just have to spend and spend to do the work. The other one that is also very valuable, the final cost of the works is you can get an additional amount on the cost of variations. Sometimes your project starts at, say, 2 million, massive house, but the madam has changed her mind in terms of what she wants, and that value has grown to 2.5 million. If you are working with the certificates, the payment certificates, you are aware of it. If you have a QS, you can ask to see the payment certificates, or you have to sign off the payment certificates. Keep an eye on how the value has increased, and that in terms of what your original negotiation was, the increased value, you can also have access to that. If your client, for some other reason, terminates the contract, your suggested 20% of the remaining fee because they ended for whatever reason. But you have already appointed the staff, for example, to do the project. That 20% of the remaining fee will help you cover the cost. You need to be aware of this. And the last one, for dispute resolution, as said previously, you can charge an hourly rate and make sure that is also agreed. We, as the SACAP Fees Committee, have received these are the queries and requests for clarification. SACAP receives the most, and there's basically just 3 of them that I'd like to take you through. The first one is the principal agent and the principal consultant and the resultant discounts. So the standard service includes for a principal consultant. Now remember, the principal consultant has to do with the design and the technical coordination. If a client comes to you and say, you are no longer the principal consultant, I'm making the project manager the principal consultant, I am going to cut your fees. The only way they can cut your fees is when whoever they've appointed as the principal consultant takes over the design work and the technical coordination of the project. As you can see, a QS or a project manager cannot do that for you. So be very aware of this little loophole. The other one is a principal agent. So they will come to you, they will say, you're no longer a principal agent, we're making the QS or the project manager the principal agent. Please ensure that the running of the construction contract has to be that person's role. You then have nothing to do with that. If they want to do funny business, but still make you responsible for running the construction contract, they cannot take those fees away from you. So in terms of the principal consultant, say, for example, it's an engineer. We've had it where there was a bridge, there was an engineer involved. He did all the design, but there was a small architectural component where he needed our services on. He did all the coordination. Yes, he was the principal consultant. But please note the reduction is only for work stages 1 to 4, not for all the work stages. By the time construction starts, you will still have to do your own inspections, your own defects lists, etc. So only work stages 1 to 4. For the principal agent, for example, there's a project manager. The reduction is no more than 10% is the suggestion by SACAP, and that only is work stages 5 and 6. That is once we are on site with a contractor. The fact that there's a project manager doesn't mean that in terms of the inception, the concept, the sketch plans, etc., that they are saving you time and money to do that work. It's only once we get to site with a contract and the closeout. So that only applies to work stages 5 and 6. So as a little example, there is a little fee agreement, a nice 60 million, nice hefty little project. It's a high complexity project, so we utilize that portion. The reduction of the fees, if not the principal consultant, only work stages 1 to 4. The reduction will only apply there, and the reduction if it is not the principal agent, only work stages 5 and 6. When they try and reduce your fees because there's a principal agent across all 6 work stages, now you know what your argument is. The other one we're looking at, and we've had a lot of queries, is repeat buildings. So it's always easier for us to explain, or for me as a practitioner in a drawing. In repeat buildings, the first place where it's easier for me to start explaining how I personally do it is I first look for the elements that is attracting a full fee. Like, for example, the gatehouses, the clubhouses. This is a full fee. As you can see, there is no repetition here. Then they do refer to prototypes in the gazetted fees. Now, a prototype means one set of drawing covers the prototype. So, for example, you can issue the same set of drawings and say this applies to building 1, 4, 18, 19, and the contractor builds off the same set of drawings. That's very important. The next step is to then determine our prototypes. So, for example, there is a standard 2-bed unit situated there, but there it is. There's one prototype, and that will be repeated across the site. However, for the driveways, they would like you to mirror. That prototype has been mirrored. That means there's a second prototype, not one prototype, because it's a second set of drawings you are producing. Remember, prototype, one set of drawings. Oh, but we do have some MIP units that's slightly different. That is additional set of drawings. We've got 2 of them. To the back of the scheme, we've made the two-story unit a 3-story unit. There is another prototype. And again, as at the bottom, because of the driveways, we want to mirror them. There is another prototype. So can you see how the prototypes, you have to be very careful about determining your prototypes and determining your set of drawings. Now, the rules say you must reduce your fees for the repeat of the prototypes with 35%. Again, only work stages 1 to 4. Again, on work stage 5, when it's construction, and work stage 6, it's closeout, you are still going to inspect each and every prototype. You can either use a cost or area calculation to do that, or a combination. So as an example, here is a quick calculation. There will be a total construction cost, but please remember that will include things like your roads, your sidewalks, your bulk earthworks, which is different. That portion must be removed because that is not the prototype. So try and isolate the construction cost of your building elements. That's our little 60 million scheme. 45 million is the building elements. Now you'll see here, utilizing a GBA exercise, we said of the 3-story, we've got 2 prototypes, and there is the repeat building area of 3-story units, 2-story units. We've also got 2, also mirrored, but of the MIP, we only have 1 prototype. The area of the prototype is this. The area of the remainder is this. 35% of that is that. And then remember that the percentage of the construction cost of the repeat element is 45 over 60. So that is 75%. So because we've done that up there, the total repeat discount is 36.76% for this specific example. Make sure that you include all the prototypes you require. The full fee applies to work stages 5 and 6. I cannot say that enough. So please remember the discount of when they ask you for what is your repeat discount, it only applies to work stages 1 to 4. The final one that we do have a lot of queries is alterations and additions, where there seems to be a bit of confusion. which we'd like to clarify. So alteration is a change in a building that affects the usability or the function of it. That attracts an additional or a suggested additional fee of 30%. So as a little example, we've had a warehouse, we've done work to it, it's become a convention center. That is a straight alteration. Where things become a little bit more difficult is with additions. And again, I'm going to use a little picture because I'm an architect. Now, we are here sitting with a resort and they wish to build a certain amount of hotel rooms as an additional wing on this resort. That wing, for example, where we increase, expand, or extend the facilities area and height, there's no additional fees on that. That is a standard fee. But please note, there is going to be a portion here where there is an interface with your existing building. For example, it was a luggage room that's now been changed to become the entrance from the old to the new, your services going over. That portion does attract the additional 30% fees under alterations. And also remember, when we work with alterations and additions in terms of our value add cell, we can offer additional services of doing the survey and the inspection beforehand. Heritage sites, of course, the 40% we look at extra for the amount of work on heritage projects, and the preparation of demolition permits. All three of these on the existing premises has also been included in the fee agreements. So please do not forget all these additional opportunities to charge additional fees. And as one practicing architectural professional to her counterparts, please remind yourself on a daily basis. And then on top of this, also remember, if you know your fee guidelines, you will know how you can take your talent and experience of what you do and charge your value and your worth for them. And then if they are not willing to listen, you can always, and what we get is, I've got somebody who can do it cheaper. Please agree with them. But also remind them that buildings do last longer even than tattoos. Thank you very much.
Oh, Helene, thank you. Thank you so much for that lovely and an explicit presentation. I think a lot of those things that you've been saying, they've been resonating with us. And you helped to clarify a lot of points that a lot of practitioners do encounter, like, charging for repetitive fees, repetitive buildings, as well as what actually happens when it comes to renovations and alterations. I think there are some questions that are coming through here. There is a colleague that asked, it's Tebo here, he says, please clarify the different roles played by project manager, principal consultant, and principal agent in terms of the PROXA agreement, and where all of them are appointed from part of the team of consultants. Maybe even to throw in the role of the architect. So it's okay, it's four things. It's project manager, principal agent, principal consultant, and the architect. I think, and just to throw one in there, I made a note here that I wanted to know when it comes to coordination. Coordination meaning also the actual overlaying of the drawings. Now, who should do that? Because we've always known that it would be the architect, but you know, yeah, there becomes a gray area that you start to encounter at stage 3 and stage 3, and then it starts being who is supposed to do what.
Yes, it's a very good question. It is not an answer that I have prepared, Boko, so I don't have anything ready here with me. You do get a very nice matrix from Proxa, giving you all the different work stages and who is responsible for everything. But from my own experience, I am currently busy negotiating a Proxa with a client as we speak, and a big part of that is going through at the end of the Proxa. There is your services and your deliverables, and each and every item I discuss with them. Am I going to provide it? Am I not going to provide it? I don't think I'm providing this. I think the QS is providing this. So for ease of reference, unless somebody like Simi has got it handy, but I unfortunately don't have it handy. And it is perhaps a question for a following webinar where we can be more prepared for that question, but it's an excellent question.
Yeah, no, thanks for that. So we should refer to the Proxa. I've seen that it actually gets quite detailed, because these definitions can also be loosely thrown around by, you know, other consultants and other project managers. And what's important is to know exactly what is your role. And the only way to figure out is at the beginning. Like, who is expected to be doing the overlaying of drawings? And always as it happens at the end of the day, you as the architect just like, oh my gosh, I know it's gonna end up being me, because you don't want to get in trouble on site. But yeah, it particularly comes to when there is a project manager who is present on a project. Yeah, because you know he can't do it anyways. Electrical engineer, they're not trained to do it. They're not trained to do it. They're taking the fees, but they're not trained to do it. So, well, that's a prayer for another day. And then anybody else the question? I can't see, Babamnedze, I don't see, yeah, I don't see the hands. I think you can see them. Is anybody that'd like to make a comment or ask a question? Maybe about the scope of works. Let's see if I can see anything here. Okay, there we go. Atusai, can you please ask your question? Atusai. Babamnedze, can you let Atusai to speak? I do. Okay, well, while nobody's coming through, I can see that there are some questions here. Okay, are percentage fees charged on the full cost of the construction, making the entire project cost 100% of the construction plus fees, or are the fees a percentage of the construction cost, meaning that the construction cost will be reduced? Okay, I don't understand this, but they also have an anonymous name to the attendee. Yeah, I'm concerned there. Advocate Toto, I see that you're answering a question that somebody is asking there. Do you want to speak on it?
Which question in particular?
Oh yes, one from Gizidze. Gizidze.
The one addressed to Mr. Shongwe.
Yes, I'm saying yeah, because I see you. I think it looks like you were typing, so maybe you can. Yeah.
So what I was saying there is that she's correct, that there's this problem that government departments have a tendency to appoint persons who only hold qualifications, but they've not gone through the process of candidature and training, and then be certified as professionals. It's a challenge that we are currently having. I mean, she makes an example about having to submit, you know, to an interior designer, calling herself an internal architect. There's no such thing as an internal architect. All the titles, you know, are clearly set out in our legislation. So these are things that we have to take, you know, up with these government department and state entities to correct.
Yeah.
Yeah.
Thanks. No, that is really true. France Rainy here says, thanks for clarifying that. Does it also mean fully detailed construction drawings does not apply to the AP, as this is now part of 4.2? What's AP, France?
I think AP, architectural professional.
Okay. Fully detailed construction drawings does not apply, as this is now part of 4.2.
Yes, that is correct. 4.1 is at the moment council submission only. 4.2 deals with the construction drawings as well as the tender drawings, everything surrounding the tender. And that is why there was that little swap in percentage between 4.1 and 4.2 as well.
Okay, that's fine. I know that SME also often says that stage 3 is actually where detailed construction drawings comes in, but that's where we've also provided for it.
No, not detailed construction drawings.
No.
Design. All design
detailed.
drawings.
Yes,
Detailed design drawings.
Okay, now that I missed you, then yes, detailed design drawings happens at stage 3. Yes. Is there any question? I just saw a whole lot of comments that came through. Ian, a lot of yes.
Yes, I see Pilasande Ncube says here that hi there, my hand is raised up on the comment side.
Oh, okay, Pilar. And then after that, it will be Mr. Malloy, who also had his hand up. Yes, Pilar. Pilar. Mr. Monetsi. Baba Monetsi. Mr. Monetsi, is there a reason why some of the colleagues are not speaking? Okay, and then Mr. AB, Muloy, you can please place your question.
Madam Chair, it feels as if the APs can't speak to us. Is there a way that IT can make it so that everybody can talk?
Yes.
And raise the questions, please. I think that might be our problem.
Yes, I think so. I think, Mr. Monetsi, if you can just maybe just put a general opening on the questions and let the colleagues just throw them in. I believe we'll respect each other as we are speaking. So can you help there by just opening the floor? Okay, Retoto, I think we still have a situation.
Let me try and get Monetsi and see what is the difficulty.
What's going on? Okay, here's a comment from Robin. I just grabbed Robin Milliner. Part of the problem with the fees is that because of the fee is based on the cost of the build, many architects wait until the design has been done and costed before sending an invoice. Clients don't like the fluid fee as it is a moving target linked to the build cost. Also, many clients feel that the fee-based on the build cost means that it is not in the architect's interest to reduce the build cost, as the higher the build, the higher the fee. Yeah, I think, Simi, would you like to comment there? I hope
I think that's exactly right. That's why those are just some of the problems that one faces with a percentage-based fee, and those are accusations that have been around since I started architecture. So I think if you start understanding the scope of service, the scope of works, the work stages, and start producing a schedule where you understand the tasks, the deliverables, and the time, it becomes clearer. The fact is that there's always going to be this this problem with the clients believing that if they specify a more expensive product, or you specify a more expensive product, or specify something that's belt and braces, for example, the client will suspect that part of that is to inflate your fee somewhat. That's something you face.
Yeah. No, thanks. You know, I liked Helene's presentation, that one that talks directly to procs as well. That really starts to itemize some of these activities. And some of these activities, a lot of times we think, no, you'll just do it as a favor, or it's a value added service, or whatnot have you. But you know, the moment you start getting into a clash with clients, they don't see those additional value added things that you had placed in. So I really like that representation of who's going to be doing what and who's not doing what. And then you start having a tangible evidence of what are you actually discounting on. You know, it's not a feeling, it's not because you think this person has money or not, but it's as per these items. So I appreciated to see that. Please, colleagues, I'd like you to be able to ask questions, but I'll just read here. Good evening, advocate. Many clients do not understand the percentage payments as per stages. They mostly prefer 50% of the total fees before get started, and 50% after the approval. And that is just that. Once the plans are approved, the client will choose who will continue with the project. How do we deal with this? This is coming from Linda. You know, Linda, I just from my bit of experience is that the moment I moved away from, I mean, there's different ways of doing things, and every practice does their different thing because they think that works better. Moving away from the deposit thing and working with the contract and the broken up stages of up till stage 6, I found that to be also very, it creates safety and comfort for me, because you do a bit of work, they sign off, they pay. You do a bit of work, which is now the stages I'm talking about. They sign off, they pay. They're not paying, it means you are also pausing and you're looking at other things in your practice. So it's risky to, well, I guess, you know, it's also risky to take 50%, because also you might not have done 50% work and then you've already exhausted your cash flow, and then you're sitting with a situation. So I think it's best to try to keep as close as possible to these created contracts. They've been done by attorneys and lawyers within SACAP and within the practices and at SAIA, just to help to make the relationship you know, healthy between the client and yourself. President, I don't know, you might have a question or a comment while I see that colleagues are not coming through to say anything.
No, thank you very much. I was just looking at the time. I think we can just move on.
Okay, no, that's fine. All right, then let's move on. We have our second last speaker, and that is our SACAP president.
Madam Chair,
yes, sir.
Sorry to disturb. We do have hands on the attendees. We can allow them if you still need them to pose their questions.
Yes, please. Okay. All right. I think if you see them better, can you just call them out to place their question? Thanks.
Madam Chair, I've gone through the questions and answers. Atusani wants to ask first. So Atusani, if you can speak now, is it possible for you to unmute?
Hi, can you hear me?
There we go.
Awesome. Thank you. I just wrote down a few points from your presentation. I think the presentation was quite good. But I think it misses the point on a few things. So I think the opening statement, we are creatives, we do not know our worth. I think that's partially correct, but I think architecture is part creative and it's part science. I think the issue comes in where I think by design, SACAP is flawed in the sense that SACAP serves to protect the public in their dealings with professionals. And the protections for the professionals are also a bit limited. I'm not saying completely limited, but I think they're a bit limited. The reason why I'm saying that is that there's so much protection from the public, but when it comes, to the protection of a professional and an unregistered person, all we get is a Facebook post. Like there's a naughty list that goes on Facebook, and that's more or less where it ends. And then I think we don't suffer from creative shame. I would say we suffer from a lack of protection because we are not prioritized by design with SACAP. And that results in, in people now having to start negotiating their fees and all of that. And that's why people feel that it is okay to go to a client and say, hey, I need you to reduce your fees because I can, get another person. And that being said, that happens because there is always another person. And then I think what your presentation addressed very well was everything after stage 4.1. But I think the bigger problems lie between stage 1 and stage 4.1. So I think what I think should be done in that sense is that, if municipalities can enforce Part XA, if municipalities can enforce public indemnity insurance, if municipalities can enforce so many things apart from the drawings, then surely professional fees can be enforced as part of municipal submission documents. I honestly think that's the best way to protect architects, because in other countries, people actually get criminally charged for undercharging in their drawings. And there's no other way to prove what people are charging apart from enforcing the SACAP document as part of the municipal submission document. For me, that levels the playing field, because then it takes an architect's stress away from negotiating what the fees are with the client. I mean, we even get instances where you have contractors and QSs who come with predetermined fees for a project. That's not based on SACAP fees, that's based on a client's budget for a project. The only way we can also protect ourselves from that is if we say that these drawings won't get approved if you do not follow the SACAP fees. So I think, yes, if you're going to run with the whole creative thing, then I think SACAP also needs to then say, fine, we are dealing with creative people. So therefore, let us be more stringent on the financial side. So protecting the architects as much as they protect the clients. And I think, so I think those are the points I wanted to make. And I think I've been lobbying for this in almost every SACAP meeting I've attended, that I honestly believe fees need to form part of municipal submission documents. I think that's as important as submitting your SACAP certificate. It's as important as submitting your Part XA certificate. It also means that there won't be people running to another architect to sign off their drawings, because what it does is it opens up the industry for people to hire other people. If no one's undercharging, then companies are making enough money to have enough employees. But because companies are undercharging so much, I mean, I think it's an open secret that from the get-go, you're already applying about a 30% discount on what SACAP already recommends. So what you're already doing is that by default, you're hiring 30% less people for your project. You're putting in 30% more effort on the stuff you have to present your project or to complete your project. You're putting in 30% more hours than you would, you know? And it's, for me, it doesn't make sense. I honestly think it should be enforced. Thank you.
Yeah. I do, you know, when you talk about enforcement, yes, I think firstly, you are right. SACAP was created to regulate the profession, but also to protect the public. And SACAP feels that part of protecting is also creating platforms and creating these programs and creating and also creating a platform professionals to be able to speak and also to participate. Now, the way I see it, not even the way I see it, it goes back to the Competitions Commission. Trust me, I'm a practitioner and I've had dreams that this thing must just be law. It must be blanket, black and white, and that's just what it should be. And the Competitions Commission keeps saying, no, but you can't fix that. It is anti-competitive. And they'll say, yes, but the doctors, they do it, and maybe other professionals do it. We want it to be fixed. And so we are continuously also fighting that battle from that end. But what they just said to us is that, okay, look, what you may do and go on to do is to start creating these surveys so that we find out what is the cost of doing work. And also, in the same way as SACAP is going to be embarking on a survey, as they've done in the past, SAIA also created a survey. They happened to have done it just in time when Competitions Commission was asking us this question. And we're able to show them that even though we are saying this is the set guideline created, and that what people are paying is not a set amount. So there's no collusion, because they did not want us, they do not want us to have that set and say this is what the set fee is. But within the fees committee, we are going to be embarking on creating a calculator that will be online, that will possibly be showing you that, you know, if you're going to discount this much, you're starting to go into a red zone and go into a risk zone. Now, how lovely would it be that we would have this calculator, you're able to take a screenshot and show the client and say, look, if you want me to go down to 37%, you are already running the risk of the project possibly not being completed or what not have you. So those are some of the activities that SACAP wants to embark on. But I think I do, when it comes to, sorry for calling you like that, I tend to be feeling very relaxed sometimes. Yeah, so when it comes down to it, it's going to be up, it'll go back to your service and what service you will be providing and what service you will not be providing. And I think that's where the confidence starts to come in. And that is to actually start to bullet point, because our backs have been pushed against the wall, and to start to bullet point what is going to be our service and what is not going to be our service. And I find that more times than not, people come to you for a reason. They decide, you know, I like this Atu guy and I want to work with him. And they usually don't go away. They don't go away because you're showing them paperwork. You're looking formalized. You have contracts in place. Thanks. Is there a question coming from anybody?
Sorry, can I
yes,
add on to what you were saying?
Yes,
I think the major problem with what you've said is nothing, you know, you've made good points, but nothing is solid. Everything is a suggestion, you know, everything SACAP does is a suggestion. And I mean, you talk about but SACAP is a judicial body, which means SACAP has judicial powers. SACAP can put things into law. You know, SACAP isn't a suggestive body, it's a judicial body. It's an arm of law, right? And that's what I'm saying. My biggest problem is SACAP isn't coming out and saying this is the law. SACAP continuously comes out and says, this is what we think the law should be. You know, like the same way you're going to put a calculator out there, no one's going to use it. People will sit and calculate, and then clients will still have the same attitude. Nothing SACAP does is altering the attitude of the clients. All SACAP saying is, architects pay us so we can tell clients what to do. Or we are paying you, not for you to tell clients how to deal with us, but we are paying SACAP for SACAP to say, look, architects, if clients come and they want to pay you 50% less, walk away from money, you know? And that doesn't make sense. Who's going to sit down and say, hey, I've got stuff to pay, I've got bills to pay, I'm not going to walk away from money. At the end of the day, that's what runs a business. Money runs a business. Money pays people. How many businesses have we seen close, you know, during the lockdown? There are so many businesses that have folded. It's not sustainable to run a startup company in architecture, because from the get-go, it already relegates you to clients who'll be paying you 15,000 Rand a project, because clients who have the money to pay will already just go to an established architect. Whether they like you or not, if you're going to come and say, hey, I haven't done any of my own projects before, but I'm going to charge you the full professional fee with no protection for myself, then the client's going to say, well, if I can pay you, then I can go pay Nico van der Meulen, for example. You know, there's nothing that holds the client to say, look, you're going to pay me and Nico van der Meulen the same amount at the end of the day. So you either, you know, there's no negotiating it. This is what law says. SACAP is a judicial body. It's a legal body. This is what the law says. So therefore, Mr. Client, you have to abide by what the law goes by. And what that does is that it puts a client in a position where, well, you can say that the client has to prove himself, whether he's actually going to the architect because of a discount, or if he's going to the architect because he enjoys his design style or his design presentation or whatsoever. But this thing of constantly putting the responsibility on the architect to dance around, you know, to dance around the client doesn't make sense. Like, architects are stressing so much already. Why would you then go to the architect and say, hey man, pay us, but when it comes to the client, you're on your own? You know, then what's the point of having a judicial body if there is no protection for us? You know, are we paying SACAP to protect clients, or are we paying SACAP to protect us?
Okay, no, thank you for your.
Can I
yes.
respond somewhat,
yes.
if I may?
Yes.
So,
yes. No, go for it,
firstly,
please.
I think there's got to be a better understanding of the law. Actually, SACAP is a regulatory body, and I'm sure Advocate Faduli would be able to answer even better than I can. But essentially, it is governed by the law, and we're acting, and SACAP is acting within the law by publishing the guideline fees as they are published. There is no law requiring SACAP nor allowing SACAP to publish regulatory fees, in other words, fees that must be charged. And in fact, the Competitions Commission specifically would forbid that. The Competitions Commission, and Advocate Faduli can either refute it or confirm it, but the Competitions Commission can override even the guideline fees, let alone the regulatory fees. So that's the first issue. The second issue around the municipalities, again, the municipality is governed by the Municipal Systems Act and so on. The municipality has no authority, nor would they wish to have any authority to regulate architectural fees related to plan submissions. That is just not part of their legislation, and neither would they contemplate that. And the third point is the question of guideline fees. It's as if what I said earlier when I was describing percentage fees, it's as if it wasn't heard. The issue is this: if you have a practice that has staff that are all 10 years plus and earning a particular salary, and I have another practice that has staff of just out of university, the salaries and the costs are fundamentally different. If you have staff drawing by hand or using AutoCAD as opposed to the Revit AEC, that's a fundamentally different expense, but one to the other. If you have a company, an architectural practice having 20 million rands worth of professional indemnity insurance and another having 2 million rands worth of professional indemnity insurance, that's another one. So fees, the fees that the guideline fees cannot apply equally to those two practices and don't apply equally to those two practices. So the Competitions Commission are saying that basically everyone in South Africa with competition law as it stands now, everyone should be free to practice. In fact, the Competitions Commission at some point went as far to say as even non-architects can practice architecture. Luckily, they stopped with that after being somewhat educated. But essentially, that's the environment that SACAP is actually, if fighting is the wrong word, but engaging with the Competitions Commission to protect to the industry to the extent that guideline fees are there. But as I said again, you have to apply, the guideline fee does not apply to any single practice and any single project. It's simply a guide. You have to understand your own cost and offer a competitive, and your own qualities and offer a competitive service. But that would be, that is the legislative framework that we're operating, and that's the best advice that one can, that's the best advice that I could give, certainly.
Yeah.
Yeah,
No, I think I'd
Yeah.
like to disagree with the point that was made.
Let me come in.
Where you are basing
let me come in before
architectural
you.
fees on overheads. And I don't think, you know, in the previous presentation, and I like what was presented in the previous presentation, that our fees are based on our skill, our efficiency, and the work we do, not on our overheads. All the overheads and all of that are calculated into what SACAP is supposed to give as a guideline of professional fees. So you can't then come tell us that if a person draws by hand versus if a person draws by Revit, it's a different thing. The skill it takes to learn to draw by hand is as long, it takes as much time to learn that skill as it does to draw proficiently in Revit. For a person to be able to produce renders, fully completed drawings to a professional level in Revit is not an easy thing, in the same way that it's not an easy thing for a person to draw by hand. So I completely disagree with the notion that architectural fees should be calculated by overheads. No, we are all professionals. The moment a person walks out, writes the SACAP certificate, writes the SACAP exam, we're not writing different exams unless we're a draftsperson versus an architect. We're writing the same SACAP exam. You can't therefore tell me that after writing the same exam, that a 20 million PI company has versus the 3 million rand PI company has should be different. We write the same exam, we get the same qualification, right? Whether one client has more money than the other is not relevant in this argument. The argument at the end of the day is we are not being protected by SACAP. And that's why I'm saying, I understand SACAP has done its work well to protect the public, right? But even in your dealings with the Competitions Commission, there is only one regulatory board for the architectural profession. There aren't 20. Architectural profession isn't regulated by the engineering profession, and there's only one SACAP, there's one regulatory profession. So with the Competitions Commission, yes, as much as you said that Competitions Commission has all of its laws and whatsoever, but unless SACAP is competing with itself, then I don't understand where the conflicts with the Competitions Commission come. You make regulations, right? If you, for example, if you can say that architects must provide this, right? For example, a person can get a master's, go to varsity and whatever, but strangely enough, we must still pay to what, 2,000, 4,000 rand, whatever it is, to get a Part XA certificate. That for me doesn't make sense. That just means that, okay, on the education side, you're already doubting what your institutions are teaching. Therefore, you put in place regulations to say that, okay, you have to get Part XA. But why can't you say that, Mr. Client, if you're going to be dealing with our professionals, like in law, like in any other professional capacity, like a doctor, then you have to pay. This is our fee, right? You don't go into an Adidas shop and then they tell you, well, the price of an Adidas sneaker is 1,000 Rand. If you feel like paying 500 Rand, I don't know, you can go negotiate. No, the price is what it is. And that's what I'm saying.
I think you have had enough time to articulate your points, but I want to come in and also reiterate what Simi said. I think the challenge is that there is no proper understanding of the law. In South Africa, we've got the rule of law. So SACAP has been given powers by Parliament, and those powers are clearly articulated in the legislation. We need to make sure as SACAP that whatever we do, it is what is been given to us by Parliament. There is nothing that is not in that act that we are able to do. That will be unlawful. So I think we need to understand that. We need to understand the law, that Parliament has promulgated the legislation, and the legislation is very clear what SACAP can do and what SACAP cannot do. We cannot do over and above that. This applies to all the professions. You go to the legal profession, you go to chartered accountant, you go to engineers, it applies across boards, not only specific to SACAP. I think the point that I want to really to address is the one that is raised by Sil Lebaleng, because the point that is being made there is that the problem is that there is a guideline fee that we published every year as prescribed by Section 34. But the government tenders, are always in conflict to the guideline fees, and it's something that really must be addressed. It really causing problems. We need to engage more with the departments so that they can be able to align themselves to the fee guidelines. Thank you, Chair.
Thanks. And I do what the registrar is saying. He's not suggesting it. These are ongoing discussions and engagements, because change does not happen overnight. I can tell you that you do know that between 2012 and I think 2015, it was a vacuum. There was no guideline fees. And that's because the Competitions Commission was just not understanding what we are doing, and they called it collusion. They were saying we're colluding, and they were like, SACAP, you will not publish fees, because as an entity, we exist among entities. And then we took it upon ourselves that, you know what, we need to go and fight a good, decent fight as SACAP for the profession, and we need to educate the Competitions Commission. So we decided to go and court this relationship, and the committee came, one of our committee members, they came with a fat set of drawings, because at the end of the day, you needed to illustrate what it takes to create a building. Because one of the senior personnel was saying, yes, but guys, what about willing buyer, willing seller? What if somebody wants to sell plans for 1,000? Why don't I just go with him? Now, you can imagine when you hear that as a practitioner, you're just like, oh my gosh, there's some big misguidance here. And we needed to come up with this person and educate that it cannot be willing buyer, willing seller. Right now, there is a guideline in place, and that's the gazetted fees. And the gazetted fees have been created like that because there was a survey that took place about 2 years ago that said, what is the cost of doing work? Because yes, we are artists and we do creative things, but it needs to still be a viable and a sustainable business. And that the profession should be able to still feel to transform and be more inclusive. And that is by, what does it cost to do business? What does it cost to pay staff, yes, overheads, because you're running a practice. And on top of that, with help from an actuary, the actuarial scientist said, okay, now, according to my calculations, this is what profit must be. And I think if we start to become a bit more scientific behind our desks and we start working it a bit more itemized, that's where the protection comes in. You're able to protect your margins, you're able to protect your risk, and you're able to protect your creative space. Yes, so that's the bit that I would want to say. I think we should move on to the council's president, Mr. Charles Nduku, so that he can come in and make his presentation. And then thereafter it'll be myself, and then we can go off, have a question and answers, and then we can go off and take lunch. So colleagues, please bear with us. Thank you for still sending in your comments and for hanging around. We have some very important things that we need to deal with. President, you are next. If you're ready, please kindly go ahead. Oh, okay.
Yes.
All right.
Yeah. Thank you very much, Tsawi. I think I'm just looking at the time, and you know, the topic that I'm going to introduce is the impact of different practices, you know, around the issue of the fees. You're looking at the tendering, you know, the procurement system that we are actually experiencing at the time and right now to get our work. And the fee guideline that we have in place, it's either negotiated up or down, and you know, it depends on what impact is going to actually give to each individual. And let me just try and share the screen. Yeah, just the understanding of the impact. So the professionals are either negotiating down or up, you know, depending on what is going to work good for them. And then this can either impact the professional negatively or positively, but recent practices of huge fee discounts have negatively impacted the profession and renders the profession unsustainable. And just go to the, so this has it reminds me of I think in 2019 when we myself and the registrar, we actually tried to address this issue of excessive discounts, and a lot of comments from the architects, you know, came, and then we were trying to actually step into that space to ask questions. Can we regulate this? And you know, it was very difficult, and I mean, even the architects themselves or architectural professionals, you know, we're very unhappy with the fact that we can tell them what to do. You know, it depends on each of them. But anyway, the law says that is why a registrar is emphasizing that, and it is called a recommended scale of fee or a fee guideline. You know, so we recommend that, and then the negotiation depends on you as a practitioner whether you negotiate up or down. And then you know, because we are actually using the cost-based construction cost-based fee, you know, that we are trying to actually perfect it. Hence, we are undergoing the survey at the moment to try and establish the real costs of different projects for different sizes of firms. You know, a smaller firm, definitely there's a difference between those two, the smaller firm and the big firm, in terms of how they earn and how they employ their resources, and then it boils down to the question of how much are they going to charge their clients. But there has been a problem with the 2015 fee guideline, the way it was established, and then it was established through an approach called a fee basket approach. This was, I think I'm going to invite Soundberry to elaborate more on this. It was established, you know, by I would say, when professionals or councils decided to just hike their fees without any substance or basis, scientific evidence that why this is the reason why they're hiking the fees. And then all of them, I mean, project managers, quantity surveyors, engineers, everyone, including SACAP, decided to hike the fees. And then the fees usually cost, before, I think around 2011, 2010, they were costing around 18% of the total project. Now, you can agree with me that they are costing close to 35%. And the clients are not happy with that, and there is no clear scientific evidence as to why the fees have been increased to that effect. And hence we've embarked on this, and the Competition Commission have questioned this, and the Competition Commission actually is have asked us to start looking at the new ways of calculating our fees. And I know for a fact that in other councils in other countries, professionals are actually, the law is prohibiting the council to actually publish the fees. Each practitioner or architect or architectural professional has to determine his or her fee as per his or her service. So we are not there yet, and we are trying to find a way forward to try and see what can we do to actually perfect this practice. But I think 2015 scale of fee, we all know that if there's a problem, it was not really accepted because of that practice. And then I would like to welcome Simon to actually talk about this 2015 and the fee scale of fee approach, which has created lots of problems for us. Thank you.
Thank you, President.
I'm going to stop sharing.
Thank you. Simon, if you can go right ahead, introduce yourself. And thank you for participating with us. Simon has been invited to participate and help.
Not sure about helping. Okay.
Well.
Okay, everyone, so just to Mr. Mduku's presentation, just to kind of expand a bit on what he was talking about in terms of the fee basket. Now, we've done some analysis, which is what I'm going to be sharing with you. And we've been doing this every year for the last, I think, 5 or 6 years, based on the gazetted fee scales that get published. Now, just before we go into it, I want to point out that this relates to a specific sector of the market. So if you're an architect doing refurbishment work in the domestic sector, the fee guidelines are there to help you, but you're the only professional that the client's really engaging with, and this doesn't, what I'm about to show you is not relevant to that. So what we're talking about specifically here is that on a bigger commercial project generally, so it's usually private sector projects, a little bit of government sector projects where you have, as I've shown you here, you might have 6 or 7 different professionals on the project. Each of these professionals has their own gazetted fees out there in the world saying, okay, based on this potential project, this is the fee that I'm going to earn. So our analysis today, I'm just showing you for an hypothetical project where the value of the works that apply to the architect is 80 million, the quantity surveyor is 55 million, because again, each of these professions has a different way of establishing what is the construction cost that applies to my fees. This is the same project, but all the professionals work out their fees differently. So anyway, so these are the numbers that we've done for the analysis. And the first point I want to make is that it's obviously going to change depending on the project. So if you're working on a warehouse in Midrand that's predominantly just steelworks, the bulk of that's going to be structural engineering and very little architecture, versus if you're working on a huge office block in the Cape Town foreshore, there's a different set of structure to that building, and that'll change the numbers that come out of it. But nonetheless, I think the principles that we're going to see in a moment apply. Okay, so what we've done is we've taken this hypothetical building and we said, okay, given that case, and we allow for inflation over the years, and we apply, we've got all the various fee scales that have been published for gazetted by person, profession by profession for the last sort of 15 years. And then we apply, so someone said they like spreadsheets and not pictures. So I'm just joking. This is, this is the raw data that we're going through, is month by month, inflation adjusted, profession adjusted. We look at all the fees that everyone earns. And the good news is we can show this to you in a picture. So this is the graph that's showing us, firstly, what the total fee basket earned by all the professionals are. So Mr. Nduku just mentioned this at the moment. So regardless of whether we're discounting, so no discounts involved, every profession every year has published their guidelines saying our fee needs to be X, our fee needs to be Y, our fee needs to be Z. If we add up all those fees together, we get to a certain percentage of construction costs. So in this case, you can see in 2006, it was around about 20% of the construction cost, according to the gazetted fees, should go to the professionals in terms of fees. And because everyone's been competing for more and more fees over the years, they've raised their fees, etc. You can see how this trend is just going up. It's closer to, and it does depend on the type of project, but forget about inflation, forget about anything else. What we're saying is that the professionals sitting around the table are going to the clients and saying, we need more money, we need more money. And the client, if you put yourself in their shoes, they're being told now, we need to, for every R1,000,000 you spend, you're going to have to spend 300,000 Rand on my professional team. Whether that's right or wrong, this is how it's changed over the last 10, 15 years. And this is generally why, because when developers are building, they work on a factor of 10%, 12%, maybe 15% of their construction cost is fees. That's why discounts are having to be higher and higher and higher. So forget about who's getting the fees. To make the project work, the overall fee basket has to be discounted more and more and more to make that project feasible. And I think we're seeing that a lot, and I'm sure a lot of you are seeing that in experience. Okay, so that's the overall fee basket. And the final point I'll just make is just how does that change individually? So how does that affect architects, particularly in relation to other professionals? So what we've got on this particular chart is showing you how everyone's relative share of the basket has changed over the years. So we benchmark it in this particular instance against 2006. So in 2006, the architect might have earned R1,000,000 Rand, the QS might have earned 500,000 Rand, the electrical engineer might have earned 200,000 Rand. Whatever those numbers are, we say that's 100. So how has that fee changed over the years? So who's getting more of or less of the share of the pie? And you can see how this works is basically the way it's gone is initially in the late 2000s, the quantity surveyors, which is the orange line, and the project managers started to earn more and more of the share of the basket at the detriment to the engineers and architects. In around 2012, and this is where the Competition Commission got involved, the engineers published a completely different way of doing their fees, and they actually shot themselves in the foot. They ended up with less of the fee basket than they ever had. SACAP, as was just mentioned, didn't change the fees because SACAP was engaging with the Competition Commission, trying to find out what the best approach is. For many, many years, those fees just remained unpublished, or new ones weren't published. And then things changed. I think in 2015, we had a massive upgrade to the SACAP fees, and you can see how suddenly the architects were back up to earning more of the portion of the pie. And then later on, the project managers said, okay, well, if the architects have upped their fees, we're going to up our fees, and then they up themselves as well. And so this bun fight continues and continues. So as things stand, where we are right now relative to 15 years ago, on the whole, project managers are earning more of the pie. Architects are actually better off than they're second best off compared to everyone else, compared to 15 years ago. And then the QSs and really the engineers have given up their portion of the fees to those other three professions. So that's really how it looks. And there's obviously a lot of conclusions or a lot of discussion that can come out of this, and a lot of saying we deserve it, they deserve it, I don't deserve it. You know, there's a lot of bun fighting going on. I think the reality is that any project has to work at the end of the day financially. So there needs to be, so this is just my opinion on it, there needs to be a coordinated approach across all the disciplines so that everyone ends up earning what they ought to be earning. But it certainly is not an ideal situation at the moment, with everyone kind of just fighting against each other rather than working with each other. So that's pretty much it. There's just one very important point I want to make before I finish up, is to say this is all about relativity. So what we've done here is we've benchmarked against 2006 as the starting point. And you can see this graph and you can look at this and say, you know, those project managers, they're nasty because they've taken the most of the pie. But that's all depends on whether 2006 was right or wrong. So it may well be that in 2006, the project managers weren't earning what they deserved, in inverted commas, and they've just played catch up. And I'll show you that if you change that reference point, so if we say, let's make 2013 the reference point where everyone's fees were the same, you can see how you can take exactly the same data and present it differently and say, actually, since 2013, it's actually the architects who've come out massively on top and have taken everybody else's fees. And in fact, the project managers are down and the QSs are down. So yeah, data is very easy to manipulate to tell your story. I think on the whole, what's been happening is a bun fight between all the different professions. And there needs to be a coordinated discussion, particularly on these projects where they are multidisciplinary, to make sure that everyone is happy or everyone is equally unhappy in terms of what the fees they're going to earn. And finally, it has to work in terms of what the person who's paying, whether that's government or a developer, it has to work for them as well. So those are just the various points I want to chuck into the discussion for today. Thank you.
Yeah, thank you, Simon, for that. And as Simon is saying, historically, what I have been told is that the different professions that would come together to make a decision on what proportion should be their fees. And you're right, we don't want to be having to fight our colleagues on what our stake should be. But you see, then we have the Competitions Commission that does not want us to actually come together around the table and say, okay, you're gonna take this much according to how much work you do. And as we know, we do the most work. It's not even the project managers. And the way to try to protect our space, the architectural space, and that is by embarking on a survey. So I'm going to start my presentation. I'm going to try to limit it. I'm going to try to just zap through it as much as possible, because I can see we're starting to lose some souls there, but most of the participants are still with us. So we sat at a point, we were at the CBE, at the Council for the Built Environment, and they were wanting to tell us that we must start charging on an hourly basis. And we said, look, but that cannot happen because we do not have that data yet out there of what is the actual cost and what does it actually take to create a small residential house or a hotel. And that means that the profession going forward, we're going to start to have to embark on building up data within our practices of the daily activities that it takes to actually complete this work. And all of this information is going to end up coming out as information that is going to be the information that educates the public. Because we'll come to a point where we're able to say, look, Mr. Client, for this type of hotel, I can confidently tell you that from the past research is going to take, I don't know, 120,000 hours, and this equates factually to this amount. Now, for us to be able to win that time from the Competitions Commission and the CBE, we decided to embark on a survey. We took some pages from, by pages I'm talking about lessons from survey that was done by SIA, which they call it the status of the profession. And we felt, no, this is good. SACAP is now embarking on their own survey. It's similar, but it affects the drafting practices, the technology practices, and the architect practices. And practitioners are not practitioners, the head of practices are encouraged to participate in the survey, because that is the only way that you can start to show the picture of what it entails to do work. I'm just trying to find sharing. My apology. I just want to share my screen, and then we can try to zap through it as quickly as possible. If you can bear with me 2 seconds, colleagues. Okay, there we go. Share screen. There. Okay, so it's about understanding the importance of participating in the benchmark survey. So it was declared that the survey will take place every 2 years. Okay, so about 3 years ago, there was a heavy debate and a strong demand by CBE to move away from ad valorem. Ad valorem fees is this percentage-based fees. And for us to move to the hourly basis, we knew that we had to firmly and firstly embark on the cost of doing work fact. SACAP sought an independent provider to help us with this. Leading Edge is a market researching agency that is conducting this super confidential survey on behalf of the council. A similar survey was conducted previously, as I said, but this time our survey is for the architectural technologists' practices, the drafting practices, as well as the architect practices. Now, this is a way for us to be able to communicate to them, Competitions Commission, that even though these are gazetted fees as a set guideline, it is not collusion. It is resolved that SACAP practices survey will take place every 2 years in order for us to beam a light on the status of the profession. Firstly, it should be known that the survey is confidential. Now, this is a very important factor, because a lot of comments had been coming in and people concerned about the confidentiality. There's a signed non-disclosure agreement between SACAP and Leading Edge Research Company. The confidentiality remains with Leading Edge Research and will not be filtered to SACAP or any of its council members. The survey is important to enable SACAP to comply with Section 34(2) of the Act, which requires the council in consultation with the VAs to determine the guidelines. Colleagues, the survey is the one tool that we have which allows us to determine what fees are actually being charged by technologist practices, architect practices, as well as drafting practices, and how these compare to guideline fees. In addition to collecting information on fees and project values, the survey also collects financial information, geographic information, as well as information on salaries paid to industry. Again, the survey is confidential. It is important that we receive this information, as it enables us as an industry to lobby stakeholders to charge fees that allow for all practices to be profitable, at the same time knowing that it is fair to the public as required by Competitions Commission. The survey communicates in factual ways to the Competitions Commission that the fees being charged in any form or matter a collusion. The reports were made available to SACAP members upon completion. I know that the past survey has been published on our website. To inform what is the cost of doing work, and it's also going to help advise on salary scales in the industry. As such, the survey is useful, not only industry level, but also to individual practices. Okay. In order to obtain solid and reliable benchmarking numbers, it is important that any practice as possible complete, that many practices as possible complete the survey. A one-person practice is a valid practice. So this is going to sole practitioners. They need to also participate in this, as well as a big practice is also a valid practice. The survey asks not only about project values and fees charged, but there are also questions covering the financial information of practices such as turnover and profits. Some practitioners have expressed a concern about making their financial and project information available. And it is a valid concern, and we can tell you and guarantee you that SACAP will not know anything about practice names and their financial information due to this MOU that has already been signed with this independent company. So we understand the hesitation. And we also like to assure practices that the individual practice information will be treated with absolute confidentiality. Colleagues, SACAP and the council will never know the names and the leaders of these practices and will only be accessible to leading edge. Remember, they have signed this non-disclosure. As a representative of SACAP and chairpersons of the Professional Fees Committee, we have a goal and objective, and that is to build this data. The compiled reports provided by Leading Edge to SACAP and the industry they show the results in aggregate only and not the individual practices. And my second last slide, as a practitioner from my side, I'd also like to engage I'd like to encourage all practices to participate. And this is a practice level questionnaire to be completed by the heads of business or the administrators. Therefore, one questionnaire per practice needs to be completed online by clicking on the link that will be sent to you, and that will be provided by email. The survey has already been launched, and we encourage you all to complete it from your side by the return date. And just lastly, yes, so please do take this survey, colleagues. You know, it's important because, you know, when there's a vacuum and there are no voices in the vacuum, somebody else is going to decide for you how you should practice. And this is what SACAP is trying to avoid. And we are hoping to end up building a library, like a compendium of sorts throughout history and time that speaks to each and every single era about what the fees were and what was happening, so that we don't repeat mistakes and that the profession carries on to be sustainable. We don't participate, then the organizations, then other organizations will tell us how to practice and how the public should pay. It's just that black and white. If you have not received any communication, please do contact Ms. Nita or the SACAP offices. If you think your details might not be correct with SACAP, please do reach out and give us your clear email addresses, or even just to check if SACAP does have your email address. And I'm just going to scan in about 30 seconds or less at the past survey. You'll see it actually looks quite lovely. You know, it shows that we've been working hard and the outcome and what the outcome should be. I'm going to try to quickly share the screen if you may allow me. Sure. I Oh, there we go. Share screen. Where is it? Yes, this is what the survey looks like. It's, you know, it looks it looks quite smart, you know, and so it shows, it really goes in depth, and it shows how many practices and what the fees are, the demographics, who's sitting where, what the big businesses are, what stake of the work are they carrying, and what are the percentages that are charging, the type of companies, what are they, the type of and what are their business practices, and what numbers of offices are in South Africa, and what is the BEE rating. And also talks about who is the macro company and who is the micro company, and what are the percentages of males and females. Talks about staffing and who and what's the count, even the demographics, and also the male gender, who is actually running these practices regarding gender. It talks about the proportionality within the practices. It looks at gender profiling and also the racial makeup, associate directors and professional directors. So it's very exhaustive, and it's helpful when we start having this as a picture of the profession. And it also even goes as far as talking about software and what it actually takes to run a practice, and what should we be earning, and who's earning what, and what income is being seen by small practices to micro practices. And it also tells you who is a micro practice and who is a small practice, and you'll be shocked to realize that you might even be a medium practice. So it's this beautiful document as I'm scanning quickly, just to respect your time. And it talks about, it goes to the projects that these practices are receiving. So it's also a useful way for you to also start to see what the market is doing amongst us as professionals. And you're able to push your numbers should you feel that your numbers are not right or however. Yeah, so it's very exhaustive, and drafting practices are participating in the technology practices as well as the architect practices. So SACAP welcomes that participation. Yes, and colleagues, I think that just ends, you know, there's salaries as well, and that ends the presentation. Yes, and wow, I think I can see that most of our colleagues are still with us. I just want to take a moment to say thank you for being with us today and for sharing some of your concerns and your questions. They're very valuable because all of us in some way or another, we are practitioners, as well as we having the honored position to be able to participate here at SACAP. So thank you so much for your lovely inputs and your questions. And please do continue to engage with SACAP. It's the only way that we can protect the public and at the same time making you know, the profession still to be as viable as possible. Remember, we are fighting a lot of factors as well because the profession has to remain viable. Helene, I don't know if you want to say something.
Madam Chair, before we go, I see there's still a lot of questions coming in from our APs attending. Can we please ask SACAP to just provide a list of the questions, perhaps to the fees committee, so that we see perhaps we can do a question and answer session between ourselves to make sure that the attendees who has not been able to have their questions answered live, that we can submit something to them for their answers.
I think that's a really lovely idea, because we will be able to possibly sit in it as a committee and answer these questions and maybe mail them back. I mean, I certainly have questions, I always do. So I think we can do that. All right, then, President, I think you can just close us down so that we can go to lunch.
Yeah, no, thank you very much, Sabi.
Thank you.
And, let me thank everyone and the participants, and we really take this seriously. And what we're trying to do here, we're trying to work with the profession to actually find solutions to our problems, because these are our problems. And we embarking on these surveys, just not for the sake of embarking on a survey. And we're trying to look on the new ways to actually determine our fees, to an extent that you know, if this can help each and every practitioner or professional to be able to work his or her own fees, you know, or service charge cost, without relying on what SACAP is published. That would be great. Yes, our act allows us to do that, but I think we need to know how much is our service valued at the moment. It's very difficult. I mean, we all know, without any question, that we've been basing our cost on the construction cost, and I think we need to divorce that ourselves from that methodology and work on our cost, the actual cost. How much does it cost the lawyers or legal fraternity? You know, if you go into their office, you know, they know exactly, you know, depending how long you're going to consult them, they're not basing their charge on anything other than the service they give. So I think that is the direction that we need to take, to actually work out to be able to get information, data, so that we understand our service fully, so that we can cost our service without relying on construction cost or any other variables that we don't have the control over. So in those words, I want to thank everyone. Thank you. It was highly attended webinar, and because this is at the center of our survival as a profession, and I think we'll definitely consider having a follow-up webinar to actually move forward on the issue of the fees. And thank you very much to all the presenters with the information, and we definitely will make this information available to the participants, so that at least, you know, people can have this information and can also assist us all as practitioners to actually come up with the cost of our service. With those words, I want to thank you. Thank you. Over to you, VP.
Oh no, I'm done. I'm done. I'm good. You have spoken, so shop is done. Have a pleasant and rested weekend, everybody. Thank you and God bless. Bye-bye.
Yeah, through you, Chair. We are going to put a link on our website to those who are requesting for the access. Check on our website on Monday or Tuesday. You will see the link so that you can download or have access to the recording.
Okay. No, that's fantastic. Thank you, Mr. Munetsi. Bye-bye, colleagues.